Record, Mr. Clerk.
There is a quorum present, Madam President.
Thank you, Mr. Clerk. Do you have any items for the record?
No items for the record.
Thank you, Mr. Clerk. We'll proceed with the first item on this afternoon's agenda, Mr. Clerk.
Madam President, Legislative Bill 1188, introduced by Senator Reapy. It's a bill for an act relating to claims against the state, to appropriate funds for the payment of certain claims, to provide for the payment of the claims, to authorize agencies to write off certain claims as prescribed, and to declare an emergency. The bill was first read on January 12th of this year. It was referred to the Business and Labor Committee. That committee reports the bill back to general file. There are committee amendments.
Senator Reapy, you're welcome to open on LB 1188.
Thank you, Madam President. LB 1188 is the state claims bill introduced by me as chair on behalf of the Business and Labor Committee at the request of the Department of Administrative Services Risk Management Division. The bill introduces the claims against the state that are required by statute to be approved by this legislature. The state risk manager has submitted tort and workers' compensation claims against the state and certain write-offs by the legislature's approval and appropriation of funds. As chair of the Business and Labor Committee, I will provide background on the process for claims and go through each claim in LB 1188. For your reference, each of you has received a spreadsheet detailing each claim, providing a brief description and settlement processing by the Attorney General's office. The dollar amounts in the state claims bill have been agreed to. Settlements or court adjustments, judgments reviewed and litigated by the Attorney General's office for the relevant state agency. Not and I repeat, not determined by the Business and Labor Committee. State claims bills are brought forth each session and may consist of miscellaneous torts, indemnification, and workers' compensation, and state insurance claims. Claims against the state pass through the state risk manager's office within the Department of Administrative Services. Claims in the amount of $5,000 may be approved directly by the state risk manager. Claims beyond $5,000 and up to $50,000 must be approved by the state claims board. Claims totaling more than $50,000 must be approved by this legislature and thus are added to the claims bill. For these claims, the risk claims manager pays the first $50,000 and the remaining amount is paid upon approval by the legislature. Included in the state claims bill are state agency write-off requests. Lastly, I want to note there are 3 amendments to LB 1188. The first is a committee amendment that I will discuss following my opening. Second and third amendments address new claims settled by the Attorney General's office. A public hearing was held by the Business and Labor Committee on March 21st to discuss and adopt added claims via amendments. For your reference, state claims summary information was handed out to each member of this legislature early this afternoon, and I will now go through the claims introduced by LB 1188. Section 1 includes an indemnification claim for $100,000, a settlement agreement between the Department of Agriculture and Richard Hensingbach. His claim was settled for $150,000. The first $500 has been paid, or the first $50,000, I apologize. Section 2 includes a workers' compensation claim of $210,000, settlement agreement between Landis Johnson and the Department of Correctional Services. His claims were settled for $325,000. The first $100,000 has been paid. Section 4 includes state agency write-off requests reviewed and approved by the State Claims Board, requiring approval by the legislature for payment. I would like to note that agency representatives provided in-person testimony for each of their respective write-off requests. The write-offs include LB 1188R1, a $201,117.22 write-off request made by the Department of Transportation relating to bad debt from various department programs. Number 2, an $8,829.58 write-off request made by the Department of Veterans Affairs relating to past due membership contributions. 3, a $1,495,029.34 write-off request made by the Department of Health and Human Services related to uncollected debt. Number 4, a $1,690,000 write-off request made by the State Fire Marshal related to uncollectible debt and storage tank registration fees. Number 5, a $931,307.28 write-off request made by the Department of Labor related to employers who have passed away or filed for bankruptcy forming uncollectible debt. And finally, $1,017,071.36 write-off request made by the Department of Labor related to unemployment insurance benefits, overpayments, and uncollectible debt. This concludes my opening on LB 1188. Thank you, Madam President.
Thank you, Senator Reapy. Colleagues, I would like to announce 70 fourth grade students from my district in Sunny Slope Elementary in Omaha. Please stand and be recognized by your Nebraska Legislature. Colleagues, also, there are 53 high school students that Senator Brandt would like to recognize from Wilbur, Claytonia. Please stand to be recognized by your Nebraska Legislature. As the clerk stated, there are committee amendments. Senator Reapy, you're welcome to open on your committee amendments.
Thank you, Madam President. The Business and Labor Committee voted to adopt AM 2923 to LB 1188. Since the adoption of the committee amendment, more state claims have been settled by the Attorney General's office. Because provisions in this committee amendment are no longer needed, and with the addition of another amendment created, AM 2923 is no longer relevant. In order to provide a cleaner approach to amending LB 1188, I ask that you vote no. I repeat, I ask you to vote no on Committee Amendment AM 2923. Thank you, Madam President.
Thank you, Senator Reapy. Turning to the queue, Senator Wayne, you're recognized.
Thank you, Mr. President, Madam President. Colleagues, so I want to tell you the genesis of these claims. And I think it's important when we talk about where these claims come from and why a bill or a state claims is important. Underneath Nebraska law, underneath the Political State Tort Act and underneath the State Tort Act, the state actually cannot be sued unless we grant ourselves the ability to be sued. So we have what's called the State Tort Claim Act. And the State Tort Claim Act allows us to be sued. In that process of the State Tort Claim Act is what Senator Reapy laid out as far as authority levels of who can decide what. There's going to be an amendment that comes up here that I'm going to speak a lot more of. I thought I was on this amendment, but I'm looking at the other amendment where it deals with a significant claim. And we're going to have a conversation about that claim, not because I'm against it, but I think it's important the body understands why do these claims come before us, because those who are here, and I would even say we could fix it this year, but the idea that $50,000 have to be approved by a board and that anything over $100,000 or $200,000 has to come to this floor is mind-boggling when you think about the injured party on the other side. We meet once a year for the first 6 months, arguably first 4 months. After we're done with session, a victim and their family can settle a case with the state, and they won't actually receive compensation till almost a year later when we come back before this body. Think about what that does if you're talking about medical bills, you're talking about all of the things that go into a serious injury. Those medical bills don't stop going into collections. Your credit report doesn't stop taking a hit. And oftentimes hospitals are quick, very quick, to put that into court. That doesn't go away. And because of how our system works, these victims don't get paid for a year and a half. Now, why is that important? Because as an attorney, you're trying to factor that in. You're trying to factor the time value of money, whereas in most litigation, you settle in the clause that has a 30-day payment. Most of them have a 10-day. They got to pay, because typically when you're dealing with injuries, whether workers' comp or a personal injury, they got bills. Those bills are part of that factor you're paying in. And you literally have people losing their house and losing things waiting on a claim to get paid. So I'm not on the Business Labor Committee, but I thought it was important to people understand that we do these bills once a year and we're paying for things that was already settled. Now, this is kind of unique in that we had a settlement that recently happened that required us to have a special hearing. But if you think about that context, you think about individuals who are dealing with debt and payment, they have to wait a year, and then this bill is passed. There's an emergency clause. Then it's going to take another 30 to 45 days for that payment to be processed. That's if there is no hiccups. We got to figure out a better way or create some better authority language for these individuals who maybe have a $500,000 claim or less. Because at the end of the day, I've always thought this was weird. Do they have authority to settle or not? Think about what we put the Attorney General in this weird predicament. Does the Attorney General actually have authority to settle a claim against the state? Because if we vote this down, then the settlement goes away. So you hold this case up in court and you continue it out saying, well, we got to wait for the legislature to approve it.
1 minute.
Or you actually settle it. And typically within 5 days, you file a joint motion to dismiss. But this body could reject the claim. So does the Attorney General actually have authority when it has to come before this body once a year? I think that needs to be fixed. I think it is detrimental to how we operate. And I think it does a disservice to the families who are waiting on payments to be made whole. Thank you, Madam President.
Thank you, Senator Wayne. Senator Clements, you're recognized.
Thank you, Madam President. Would Senator Riepe yield to some questions?
Senator Riepe, would you yield?
Yes.
Senator Riepe, on the state fire marshal claim, it's on the back side of the handout I received. I see a number of $1,690. When you were describing that, you said $1,690,000. I just wanted to clarify the dollar amount of the state fire marshal debt write-off.
Maybe it was a rounding error on my part.
Is 1,690 the correct number?
Let's see, I'm trying to look back here over my figures. What is it? What just give me 1 You're correct. It is $1,690.
Thank you. I was pretty sure that was just misspoken.
Do you have a heart attack? Did I?
Well, a million here and a million there, and it adds up. The total of all of these, do you have a total of all of these?
I have a total of,
well, I just
I have it
did
here.
an ad, a quick ad. I got $12.1 million is the sum of all of these claims. You said to vote no on one of your committee amendments. Is that going to take out any of the items on here?
Well, I think where that number is diminished is some of this was covered by excess coverage insurance, particularly on the one that the automobile hot pursuit one, which took it from 7.5 million down to some I believe it's $4 million.
All right, well, but the 4 million is after insurance has paid some of it then, right?
Yes, but I'm trying to look where I one time had it totaled up here.
Well, I'll let you go. Thank you for now. I may get back on with,
Okay, we can follow up with you too to make sure that we do. It is important that we get these numbers clarified, and especially because of the Appropriations Committee, we owe it to you to get you the exact and right number. We will do that.
thank you, Senator Reapy.
Thank you.
I also checked, seeing the $12.1 million total here, that concerned me because there's not that a lot of money to the floor. In checking with the Director of Fiscal, in the budget, I recall that we did transfer some money to the state insurance fund. A lot of these are paid from the state insurance fund, and we took out of the cash reserve $3,250,000 to a state insurance cash fund, which most of these will come out of. There are some workers' compensations claims that the workers' compensation has a claim fund in that agency, and those there are adequate funds to cover those. And what I've been told is of this 12.1 million, 100,000 is what's going to come off of the floor. And I'll double check that with fiscal, but that's what I was told with a quick ask just a little bit ago. So that does make me feel better about these claims. And how much time do I have?
1 minute.
Thank you. I think that's all I have for now. I may get on another time. Thank you, Madam President.
Thank you, Senator Clements and Senator Reapy. Senator Michaela Cavanaugh, you're recognized.
Thank you, Madam President. Would Senator Wayne yield to a question?
Senator Wayne, will you yield?
Thank you, Senator Wayne. I apologize. I wasn't 100% tuned in to what you were talking about, and then I started tuning in and I wasn't quite clear. Can you give us you were talking about the AG settling claims. Could you just refresh on that?
So the AG, when you sue the state, is the attorney on the other side. And when you settle a case, the AG acts like they have the authority to settle that case. But when Senator Reapy laid out in his opening the thresholds for paying claims, it seems like anything over 200,000, and I think that's the number he used, has to come before this body. And so I'm questioning whether the AG has authority to settle claims if this body can vote down that claim settlement. And if the body votes down the claim settlement, and especially if that attorney dismissed the case thinking we had a signed agreement, that claim could be statutorily barred. And that raises some concerns I have.
What would happen if we voted down to pay out a settlement? What would happen then?
It would depend on where they were in the statute of limitations. So on a personal injury, well, within a state, against the state, you have a 2 years statutory limitation to first, within 1 year, you have to file a notice. Then within 2 years, you have to file litigation. So if it's outside of that 2 years, which based off of the claims that I see before us, they all are, then they are forever barred. They can never go back and refile a case and because the 2 years is gone.
So if the AG settles the claim, then we decide to not pay out the claim, what would it be? The plaintiff then has no recourse?
If they're past their statutory limitations or repos, absolutely. And based off of the claim numbers I'm seeing, one was a CI 20, which means it was filed in 20, then they are barred if we were to deny those claims.
Wow. Okay. So how can we fix that?
Well, I think from general and select, I think Senator Reapy might want to have a conversation around threshold limits and how we can increase those. If not, I definitely think going into next year, business and labor needs to look at threshold limits to make sure they have more authority And then we probably need to put something in statute that says if the claim is voted down, the statute of limitation does not apply for the purpose of that claim. That way that person can at least have recourse.
Okay, thank you. That's really important history. So thank you, Senator Wayne. I yield the remainder of my time.
Thank you, Senators Wayne and Kavanaugh. Senator Megan Hunt would like to recognize 44 fourth graders and 3 teachers from Weston Hills Elementary in Omaha, Nebraska. Please stand and be recognized by your Nebraska Legislature. Senator Riepe, you're welcome to close on the committee amendments.
Thank you, Madam President. I will be brief, and I want to thank Senator Wayne for noting out this significant challenge in terms of the payment process. And the actual amount that is required from this body is $50,000. So it's a very small threshold, and we will take a look at that going forward. We may turn this around fairly quickly with Select, so we'll see. If we don't, we'll make a pledge to at least study it for sure in the next session. Thank you, Madam President.
Thank you, Senator Riepe. The question before the body is the adoption of AM 2923, the Business and Labor Committee amendments. All those in favor, vote aye. All those opposed, vote nay. Record, Mr. Clerk.
No ayes, 35 nays on the adoption of the committee amendment, Madam President.
Thank you, Mr. Clerk. Next, the committee amendment is not adopted. Next item on the bill.
Madam President, Senator Riepe would move to amend the bill with AM 3018.
Senator Riepe, you are welcome to open on AM 3018.
Thank you, Madam President. The Business and Labor Committee held a hearing on AM 3018 to LB 1188 on March 21st as a result of a new state claims settlement by the Attorney General's office since the initial hearing of LB 1188. AM 3018 amends LB 1188 by including 2 workers' comp settlement claims in Section 2. The first claim is divided into 2 parts. $10,164 to Christine Schmidt and $125,000 to Hanley Law on behalf of Christine Schmidt for injuries sustained in an accident injury arising from her employment at the Nebraska Department of Veterans Affairs. The second, $350,000 to Downing, and Urbon on behalf of Santino Madid Akut for injuries sustained in an accident injury arising from his employment at the Nebraska Department of Correctional Services. AM 318 also includes 1 new insurance fraud tort claim for the state divided into 3 payments. $4,450,000 to the trust account of Simon Olson Law Firm, $2,500,000 to New York Life Insurance Company, and $500,000 to Pacific Life and Annuity Services. This is a personal injury claim filed on behalf of Miles and Christina Margetes, resulting from an alleged police pursuit. Pursuant to Nebraska Revised Statute 81-8215.01, The state of Nebraska is strictly liable for injuries caused by innocent third parties resulting from a vehicle pursuit. According to testimony provided by a representative from the Attorney General's office, the state had excess auto liability insurance coverage, which included coverage for police pursuits following payment by the state of the full $7,500,000. The state third-party administrator, NRMA, will submit claims for reimbursement from the state's excess carriers, which the Attorney General's office expects will be paid within approximately 30 days from the reimbursement request. Of the $7.5 million, the state will be reimbursed $400,000 from our first layer of excess coverage and $4 million from our second layer of excess coverage. Accordingly, after reimbursements, the state will have paid $3,100,000 on this claim in addition to premiums paid for that policy period. Due to the rising premium cost, the Office of Risk Management did not renew the state's auto liability insurance policy, which took effect on July 2nd, 2023. This means that the state is currently fully self-insured and does not have any excess insurance coverage for any motor vehicle accidents or police pursuits. Moving forward, if the above claim occurred today, the state would be responsible for the full $7.5 million. More information on these claims are noted on the state claims summaries handed out to you just recently. And I ask for your green vote on AM 3018 to LB 1188. Thank you, Madam President.
Thank you, Senator Riepe. Mr. Clerk, for an amendment to the amendment to the amendment.
Thank you, Madam President. Senator Riepe would move to amend AM 3018 with AM 3113.
Senator Riepe, you are welcome to open on AM 3113.
Thank you, Madam President. AM 3113 amends AM 3018 by including two new state insurance fund tort claims recently settled by the Attorney General's office. The first personal injury claim filed on behalf of Abigail Comstock resulted from an alleged police pursuit. The second is a personal injury claim filed on behalf of Amy Comstock, not to be confused, these are sisters. They're resulting from an alleged police pursuit. The parties mediated this matter on March 15, 2024. The Attorney General's office entered into a settlement with both Abigail and Amy Comstock for $150,000 each in full and final resolution of their claims resulting from the January 3rd, 2019 accident. The first $50,000 of each claim has been paid. More information on these state claims were handed out to the body earlier today. I ask for your green vote on AM 3113 to AM 3018. Thank you, Madam President.
Thank you, Senator Riepe. Senator Rain, you are recognized.
Thank you, Mr. President. Will Senator Riepe yield to a question?
Senator Riepe, will you yield?
Madam President, I'm sorry, Madam President.
Yes, I will.
Senator Riepe, I was looking on this paper. Is this the amendment that deals with the $7.4 million?
No, that is a different case.
So this amendment, okay. No, your amendment's on the board though.
I'm sorry?
The Miles and Christine 3018, is that the one you don't?
33018 was Christine Schmidt, and that was the one that actually her settlement was with the Nebraska Department of Veterans Affairs. and that was in Amendment 3018. This amendment is 3113, which are the two tort claims of Abigail and Amy Comstock.
Right. So on page 1 of your handout, it talks about Miles and Christy Margaret's plea settlement pursuit.
Yes, that was the 7.5 million.
Okay, thank you, Senator Riepe. Colleagues, I just want to point out something that I find interesting, and maybe you'll find it interesting too, maybe you won't. If a police officer conducts a high-speed chase and hits a third party or injures a third party, we are strictly liable. What that means is that if you engage in a high-speed pursuit and somebody is injured, the state is strictly liable. That means the state owes to make you whole. You know what's interesting is that same officer commits child sexual abuse. The state is exempt, is immune from prosecution as far as making that child whole. That's what Senator Halloran's bill does on LB 341. It makes sure that those who are sexually assaulted children by an employee or the state, we'll just say the state, or a political subdivision should be held liable. So think about the laws that we have here today. We have a law that says if we are chasing after the so-called bad guy, we will hold anybody who is a third party, we will make them whole. We will bring them to the status that they can continue their life to the best of their ability because we will make them whole. Regardless, we engaged in the police chase. State patrolled, chased after the bad guy. Third party, we're going to make you whole. That same state patrol officer sexually assaults a kid. State, you don't have to pay a dime. And in fact, you can't even sue. Make it make sense to me. Somebody here today, make it make sense to me. Because when you put it in that perspective, everybody will think that's a problem. Well, guess what? There's an amendment on this bill that will deal with that, and we're going to take a vote on that today. We're going to take a vote on it saying that if we can be strictly liable to a third party in the police pursuit at a bare minimum, the state should be liable when a state employee commits sexual assault on a child. Thank you, Mr. President.
Thank you, Senator Wayne. Senator Wayne, you're next in the queue. He waves. Senator Conrad, you're recognized. Senator Conrad?
Thank you, Madam President. Good afternoon, colleagues. I want to thank Senator Riepe for his leadership in bringing forward the claims bill, and I also want to thank my friend Senator Wayne for his ongoing consistent advocacy in regards to ensuring access to justice for those harmed by their government and government agents and entities. And I'm grateful that we have this opportunity to revisit this topic on this issue, on this bill, and I am looking forward to forthcoming amendments to try and broaden our lens on how our state approaches some of these issues. I'm sure there are plenty of people watching or in the lobby or maybe even within the legislative staff who can help correct me if I'm wrong, but I think Senator Wayne was asking a rhetorical question, of course, make it make sense, but let me posit one answer to that question. The reason that we have strict liability for citizens who are injured in a high-speed police pursuit is not just because that's the way it's always been or that's how the common laws developed, et cetera, et cetera. The reason we have strict liability, the reason we have a higher standard when law enforcement agents engage in a high-speed pursuit, and injure or kill a member of the public. The reason we have a different standard for liability to ensure access to justice in these highly charged situations is because senators on this floor saw fit to set those boundaries in our public policy. Senator Chambers and other senators worked for years to ensure there was a higher standard in place when members of the public were injured in those kinds of situations. That's exactly what Senator Halloran, Senator Dungin, myself, and others have before the Judiciary Committee to varying degrees with varying nuances to them, but trying to undo what we see as wrongs set up by the courts, artificially denying access to justice for Nebraskans who are injured by their government, purposefully or negligently. Whether that's in the prisons, whether that's in the schools, whether that's in Health and Human Services or other contexts, it's important to know why we have strict liability when it comes to police chases. It's because this legislature said we should. Because we said we're going to set the public policy of this state to ensure that those citizens who are injured or killed in these situations have access to justice through compensation by setting an appropriate legal standard to effectuate that goal. Senator Dungin, Senator Halloran, myself, and others are trying to rebalance the scales of justice in support of Nebraskans who've been injured by their government intentionally, negligently, in schools and prisons and other contexts through pending bills in the Judiciary Committee that can and should be a part of this debate, perhaps, or can and should be a part of the debate on other Judiciary Committee matters that are forthcoming
1 minute.
in the remainder of the session. But this is a prime example, thank you, Madam President, Exhibit A, if you will, about why do we have strict liability? It's because this body said we should. The wisdom of the senators who held these seats before us said, this is a serious situation to try and prevent and deter bad decisions by the government. We're going to heighten the standard. We're going to ensure access to justice through fair compensation for those that are injured by addressing our civil practice statutes and removing protection that shields government actors. We're asking you to do the same when it comes to little kids injured and other vulnerable Nebraskans. There are remedies before this body to do that this session. We've talked about them in great length on the mic. They can and they should be a part of this debate. Thank you, Madam President.
Thank you, Senator Conrad. Seeing no one else in the queue, Senator Riepe, you're welcome to close on AM 3113.
Thank you, Madam President. I'd like to thank everyone for their participation in the discussion. And obviously, we have a moral obligation and a legal responsibility to own up to our failures. And when we do, we need to settle and be fair in that process. With that said, I would ask this body to vote green on first on 3113 and then on the subsequent underlying bill. Thank you.
Thank you, Senator Riepe. The question is the adoption of AM 3113 into AM 3018. All those in favor, vote aye. All those opposed, vote nay. Have you all voted who care to? Record, Mr. Clerk.
33 ayes, no nays on the adoption of AM 3113, Madam President.
It is adopted.
try it. Let's see if this one goes through and then we'll correct it.
Seeing no one else in the queue, Senator Riepe, you are now welcome to close on AM 3018. Senator Riepe waives closing. The question for the body is the adoption of AM 3018. All those in favor, vote aye. All those opposed, vote nay. Have you all voted who care to? Record, Mr. Clerk.
38 ayes, no nays on the adoption of AM 3018, Madam President.
It is adopted. Seeing no one else in the queue, Senator Riepe, you're welcome. Excuse me, there's another amendment.
Madam President, Senator Wayne would move to amend with AM 3196.
Senator Wayne, you are recognized to open on AM 3196.
Thank you, Mr. President. Colleagues, this is Senator Holloran's LB 341. So there are a couple things that we could talk about. We can go into more detail if people have questions, but here's what it comes down to. It comes down to the fact pattern I just said, that if a state patrol individual is in pursuit and injures a third party, the state is strictly liable. Yet if the same state patrol person sexually assaults a kid, whether they're in custody or out of custody, that is considered an intentional act. And based off of the recent Supreme Court dicta, the state is immune from being sued. Now, I don't want this to be confused with Senator Duncan's bill, LB 325. That is about when somebody is in state custody. That is about a third party as the actor. We'll have that debate too this year. The difference is a state actor versus a non-state actor. This is very, very limited. This is a state actor who is committed sexual assault of a child. I think at a bare minimum, we have to make a decision as a body. Do we focus on protecting big government or do we focus on the victim? So there is concerns about a floodgate being opened. And here's what I would tell you. One, if our state employees are committing that many sexual assaults to children, we have a problem. Two, this was the rule up until 4 years ago when the Supreme Court changed it in Mosier case. And the dicta, which means not the legal holding, but it's a legal holding in the sense that it applies to everybody else. This became an issue where even state employees could not be held liable for actions by the state. So we are trying to fix that. Now, the third guardrail to this idea that we are opening up the floodgates is the litigation process itself. And I want to talk about that briefly during my opening. In order to sue a political subdivision or the state, you have to first provide notice within 1 year. So you have to provide notice. Then you have to file an actual lawsuit. And the notice is typically a demand letter that says you are hereby notified under all these sections of law, Political Tort Claims Act, State Tort Claims Act, et cetera, and we demand, et cetera. Now, for Political Tort Claims Act, the cap the city, county, any political subdivision will ever pay is $1 million. So that right there should alleviate concerns when it comes to your back home city, your back home county. At worst case scenario, the state is not capped. But let me talk about the safeguards when you go through a litigation process. So there is notice that is required. Then you file a complaint. At the complaint stage, and there's only like 7 phases to a lawsuit, so just bear with me. But at the complaint stage, They get to file, when I say they, the state gets to file two things. They can file a motion to dismiss, which just happened here in Lincoln, or they can file an answer with the countersuit. I didn't use a third one because the state never usually sues somebody back. So it's either a motion to dismiss or a counter or answer. And in the answer, they can deny everything and they can have affirmative defenses, et cetera. Then the second stage of litigation is discovery. At that point, you exchange a whole bunch of information. Sometimes you'll go to court and say, I compel the state to give me more information. But what you're doing at this point is trying to figure out all of the information regarding the act and then the damages from the act. So there's another safeguard right there, is that you are giving, the state is giving the plaintiff, the injured party, information on why they shouldn't be liable and what they should do to mitigate risk. After discovery, and here is the critical stage in litigation that nobody talks about, because we just think if we open up the doors, money's just going to come flying out, and that's not what happens. It's called the motion for summary judgment. What that means is that if there are no disputes in facts, then the case is typically over. It could be in favor of the plaintiff or against the plaintiff. But it's also, does the law allow it? So you get all this fact evidence in, and the state will automatically file a motion for summary judgment. So you have to go before a judge and say, here goes my case. Here are the reasons this should continue to trial. And I have to meet a minimum threshold that there are disputes in facts, that the damages are correct, that experts on both sides say that there's a duty that may have been breached. And a judge takes up to 90 days to say, yes, I dismiss the case on behalf of the state, or I will let the case go forward. And the case may only go forward with one or two portions of the case, depending on how you plead the case. So they can even grant a partial summary judgment. That is a huge safeguard for the defendant, in this case, the state. You have to meet a minimum threshold to even get it to trial. Then you have to go to trial. And underneath the political torts claim, state tort claim, it's in front of a judge. That judge is the arbiter of the facts that are being presented. So there's your third safeguard in litigation, that you have to actually put on a case, and it has to actually mean something to that judge in order for you to prove your case. So it isn't just that the state is liable, you have to prove your damages. That means you have to show with medical records, you have to show future medical records. Those future medical records have to be reasonable. So that means you can't just say, I'm gonna have a lifetime of therapy. You have to actually have a therapist go in and document, here's how long we think this, and here's the stages, and here's where we get to, in order for this child, in this case, to be close to made whole, if at all. Then the last thing is, even after a judge comes back and says, yep, I agree with the plaintiff, the state gets to file what's called a motion notwithstanding the verdict, motion notwithstanding the judgment, depending on what jurisdiction you're in. So then they get to go back in front of the judge for the fourth time and say the plaintiff didn't meet its burden. Even if you take everything into account after the trial, you still didn't meet your burden. Then the last and fifth guardrail is an appeal. So it isn't like you're going to walk in here and say this child was sexually assaulted by X and money flows. It never works that way. And that's the misnomer in this body, is this is going to cost millions. But if you base that on the premises that this is going to cost millions to the state, then how many claims did not come before us right now of kids being sexually assaulted? And if it is costing us millions, then clearly we have a problem with how we're hiring people. So to me, this is a no-brainer. If a police officer or state patrol or an employee, in this case, a police officer is in front of a state patrol, is strictly liable if they are chasing the bad guy. We are trying to stop more damage. We are trying to protect people because we know this criminal is right in front of us and we are speeding to catch him before they do any more bad acts. I'm sorry I got in a car accident. Don't worry, the state is going to cover it all because what's more important to us is catching that bad guy. That's our policy. On the flipped end, if that same cop sexually assaults somebody, there is no recourse under state action.
1 minute.
Some people will argue they can go to state court, they can go to federal court. Federal court is very difficult and it has to apply to a 1938 claim, or you have to say it's a Title IX claim. There's multiple other ways you have to get there. But why shouldn't we allow our laws to give that family remedy, to give those parents remedy, to make that child whole? Thank you, Madam President.
Thank you, Senator Wayne. Senator Michaela Cavanaugh, you're recognized.
Thank you, Madam President. I rise in support of AM 3196. Thank you, Senator Wayne, for continuing this conversation and continuing to bring forward this issue. We should be making the children who are victims of assault whole as much as we possibly can. And the fact that we as a state deny them that avenue from the state seems pretty absurd to me. And I have yet to hear the arguments that make any sense, especially if we're paying out from the state is liable for a high-speed chase with the police damages. Then we should be paying out damages from high intense trauma for a child. And we should be conducting better overview and oversight of who we are hiring, but that's for another day, I suppose. So I will be voting for AM 3196. I support Senator Wayne's amendment and I support bringing it forward today. Since Dr. Corsi flew through with 28 votes this morning, I really tried to keep to the things that I thought would be most important to the conservatives in this body: fiscal responsibility. Fiscal responsibility, I guess, is it. So I really did divert away from the topics that are also important to me, which is the starting point of the lack of government transparency in every avenue of Dr. Corsi's history, and then additionally his social media. So there is, I don't know, I have 22 pages of multiple social media posts, and I'm going to share some of them here, and I'm not going to share any that require any sort of warning to censor, just warning that they are things that I think are inappropriate and unbecoming of the head of the largest agency that provides services to minorities and children across the state. One tweet was, "Life's too short to deal with preferred pronouns." There are individuals who work for DHHS who would like their preferred pronouns to be used in the workplace. So the fact that this is a stated viewpoint of Dr. Corsi is concerning and discriminatory. The communist lockdowns did nothing to advance public health. They were about government power and control. The American people deserve better. They deserve freedom and respect for their personal responsibility. So Nebraska has touted pretty good outcomes when it comes to the pandemic, and that is because the two largest communities enacted lockdowns, as they describe it, enacted mask requirements and shelter in place. And we have health agencies that were doing reporting and research and tracking. So to have the head of DHHS clearly in opposition to that. And mind you, this is something that started under former Senator Trump's administration and carried on through the next, did I say Senator?
1 minute.
President Trump, sorry. Indicates that this is not a partisan issue, but it was a health crisis, and this is how health crises are typically handled. So it is concerning to have this preconceived notion that there is no acceptable shelter in place or public health measures to be given by the current CEO of DHHS, especially as this body tries to move more of that authority into their hands and away from the hands of our public health departments. I find that extremely concerning. And several of you colleagues, I talk to your public health departments at the height of the pandemic on a regular basis, and they were struggling because they couldn't issue any type of mandate, and they had people dying, and they had medical professionals leaving because they couldn't handle it anymore, and all they were asking for was a mask mandate. That was it, and they couldn't get it.
Time, Senator.
Thank you, Madam President.
Thank you, Senator Michaela Cavanaugh. Senator Holcroft, you're recognized.
Thank you, Madam President. This is a tough one. This was LB 341, which is Senator Halloran's. I have great respect for Senator Halloran and this bill. But it not only opens up the state to suit, but also the counties, the cities, the schools, any political entity can now be sued for child sexual assault under their care. And I would point out that although the state trooper the state could not be sued currently, the state troopers could certainly be held responsible. And the perpetrator in all of these cases can be held responsible, either both criminally and civilly. So it's not that the victim doesn't have recourse, it just doesn't have recourse to sue the government. It's sovereign immunity. And I just wanted to point out that the committee voted it out 5-4, 1 against, that was me, 1 absent, and 1 present not voting. So, and the testimony was, being on the Judiciary Committee, it's not fun listening to some of these cases. We had 5 people who brought forward their personal experiences and their frustration at not being able to get satisfaction, although they could. The perpetrator was disciplined, some in prison, some with fines or penalties, suits. But there were 5 individuals who came forward as proponents. The Nebraska Association of Trial Attorneys came as proponents. The Nebraskans for Founders Values came as proponents. The opponents were the Nebraska Association of School Boards, the League of Association of Risk Management, the Nebraska Municipalities, the League of Nebraska Municipalities, the Nebraska Intergovernmental Risk Management Association, the Department of Health and Human Services, the Nebraska Association of County Officials, the Nebraska County Attorneys Association, and the Nebraska Attorney General's Office. Those came in opposition to LB 341. So I say tread carefully with this bill because this opens up your political entities to lawsuits, and they may be limited to $1 million, but as we just found out, it could be in the multi-million-dollar range somehow. And I'm sure Senator Wayne can amplify on that. But that all comes back on the taxpayer. Insurance will cover some of these, but school boards, the only way they can pay for these is through increased premiums on their insurance or through raising of property tax. So we're going to do all this work for property tax, and then we're going to open up the political entities to lawsuit. So I am opposed to AM 3196, and I recommend your no vote. Thank you, Madam President.
Thank you, Senator Holcroft. Senator Michaela Cavanaugh, you're recognized.
Thank you, Madam President. Well, I do not share Senator Holcroft's admiration of Senator Halloran, but I think this is good policy. So I'm still going to vote for 3196 regardless of who the introducer is. I bring that up to illustrate for you all that this is how this place is supposed to work. This is how it's supposed to work. You're supposed to listen. We're supposed to be deliberative. We're supposed to have conversations and debate. And we're not supposed to care about who the introducer is. This is good policy. So I'm going to vote for it, regardless of how I feel about the person that introduced it. I am disappointed by this morning. Very few people participated in the conversation about Dr. Corsi, and the debate was less than 2 hours. I think it was an hour and a half, maybe. And then the question was called, and members of the committee were in the queue who had not spoken, who had not informed the body as to why they voted for Dr. Corsi. This is a very serious position that just flew through. And I am curious why 28 of you voted for this person who clearly has questionable judgment. He worked for the state of Wyoming and worked for a private company on the side with another employee from the state of Wyoming. And he didn't disclose that to us. He didn't disclose that work to us. He worked for the state of Missouri and drew paychecks from 2 different agencies and had to be told publicly to stop. And a month later, he still hadn't stopped. He and Epiphany followed each other around the country. They somehow got a $10 million no-bid contract in Nebraska with zero evidence that they've ever even had a $1 million contract. Also zero evidence of who their employees are beyond the one person. A $10 million no-bid contract, and a month and a half later, they recommend him to be the new head of DHHS. And none of you find any of this to be questionable? Then that same company has logos all over their website of all the different places that they worked, which is how I knew that he worked in the same places as them. And then guess what they did? They took that off their website because they didn't have the permission of any of those places to advertise that way. And the woman who started the company, she started it while she was working for the state of Utah and did it off taxpayers' backs there, drawing money from the state of Utah in her professional capacity and in her consulting capacity, which was, again, another scandal. But nobody here seems to care at all about good governance. It is bananas to me that 28 people voted for that. Bananas. And then somebody under him bought a chair for restraining children.
1 minute.
And he was in charge. He was in charge. Whether he knew about it or didn't know about it is egregious in either direction. I don't know what it takes for you all to care about the state of Nebraska, about the people of Nebraska, about the children of Nebraska, about the children that are in foster care and system involved in Nebraska, the children that don't have access to enough food, the children who are going through a gender identity crisis. I don't know what it's going to care, but apparently as long as they have an R behind their name, you don't care. You don't care. All you care about is towing the line, and that is what you did this morning. You towed the line. Thank you, Madam President.
Thank you, Senator Kavanaugh. Senator Blood, you're recognized.
Thank you, Madam President. Fellow Senators from all, I actually stand in support of Senator Wayne's amendment. And I want to talk a little bit about why I don't think government should be above the law. And I know we're talking about tort claims, but that is part of making a victim whole. And you heard Senator Wayne, who may have unknowingly quoted me from our exec session, is that what you don't understand is that especially children rarely have the opportunity to be made whole after sexual assault. That's why you see so many adults with longstanding issues and trauma and PTSD from incidents like that, especially when it's a person of authority. And so being able to file a tort claim allows that family to get that child the counseling and the help, and sometimes they need medical help, depending on how they've been violated, that they truly need. I've looked at the bills this year and shaken my head on some of them because there's a big theme about sex trafficking this year. And we're always saying, it's about the children. You guys have been apparently programmed that on every single bill, it's about the children. But when they bring something up like this, it's not about the children. It's how we're opening the doors and people are going to take advantage of it. Well, if that's indeed the case, as you've heard several people say, then boy, we're doing a poor job of hiring and vetting people. To think that we would open the doors for child sexual assault and be concerned that there'd be too many requests to sue the state seems counterproductive to what you've been talking about all year long on these child pornography bills, on these sex trafficking bills, where you continue to say it's for the children, it's about the children, it's about the children being safe. So if we want children to be safe, it has to be more than criminal. We have to give that child who is more than likely the perfect victim, more than likely groomed, maybe having family issues, looking for an adult to pay attention to them, depending on the circumstances. I'm just painting a scenario, not all scenarios. They may not have the money to get that child that help. And so we get to live with the fact that that child never got help because we weren't willing to be brave today and we weren't willing to pass this amendment. If what you have said all year long, and every single sex trafficking bill on the pornography bills is that it's about the children, then how could you not vote for this amendment if it's about the children? You have to make victims whole. You have to allow them to get the resources that they need so they can grow up to be healthy human beings, healthy adults. We talk all the time about how much shortage we have when it comes to licensed mental health professionals. It's hard for people who don't have income to pay for these types of things, to pay for mental health if their insurance doesn't cover it, or the amount of mental health help that they may need. There may be medical procedures as a result of the sexual assault, especially on a child, that need to be done in the future. Why should that cost fall on the shoulders of those parents, of the people taking care of that child? It is our responsibility. And I think it is overemphasizing what will really happen by saying it's going to open the gates. Because if that is indeed the case, you must not think very highly of these victims to think that their only purpose would be to try and generate income from the state. I think that is very sad. And I think that is very uncompassionate. Thank you, Madam President.
Thank you, Senator Blood. Senator Conrad, you're recognized.
Thank you, Madam President. Good afternoon, colleagues. I just wanted to add a few counterpoints to my friend Senator Holcroft's commentary that he brought forward when we debated these issues a few weeks ago, and then again today. And to be clear, he has a right to his opinion, and he expresses it as he sees fit in representing his constituents and his point of view. But let me remind you of a couple of other things that perhaps Senator Holdcroft ran out of time on the mic or conveniently left out. So when Senator Holcroft suggests that the only remedy available to citizens who are injured or harmed or killed at the hands of their government agents and entities, that their sole recourse should be the criminal law and or an individual judgment. And I just want to remind folks of a couple of things about how the law works. Just so that you know, the average teacher salary in Nebraska ranges from $38,000 to $68,000 a year. The average Nebraska salary for law enforcement ranges for $34,000 to $80,000 per year. The average annual salary for a corrections officer ranges from $38,000 to $66,000 a year. So no doubt these people who pursue careers in public service are not doing it to get rich. But mind you, Senator Holcroft and others say the only recourse for the citizens should be to go after these individual bad actors, and we should have special rules for government when they act negligently or wrongly. Well, let's keep in mind a couple of things. If these individual bad actors end up in the criminal justice system, their income's going to be reduced to zero rather quickly. While those processes carry out, it's important to note that they have a modest income and most likely modest assets to draw upon that are not going to be enough to cover the kinds of counseling and other issues that people who are harmed by their government are going to need. Additionally, I have heard my friend Senator Holcroft and others say we should run government like a business. But then, in the same breath, in this instance, we'll say, no, actually government needs special considerations and special protections and should be held to a different standard than we treat private businesses, for example. So which is it? I've also heard Senator Holcroft and others say, and I disagree with their approach, to be clear, but they say we have to have tougher penalties on everything because that's the only way to deter crime. But then push it back against tougher penalties in the civil justice system because they don't think it will deter bad actions by government entities and agents who harm citizens. So you can absolutely have your point of view. You can absolutely express it as you see fit, but I'm going to call out hypocrisy when I see it. And if we're going to say government should be run like a business, then we should not be afraid to hold government to a similar standard as we have in the private sector. We shouldn't give our buddies in government a special deal. But that's what you're saying is okay to Nebraska taxpayers and vulnerable Nebraskans who are harmed by their government, intentionally and negligently. If you're going to say the only way to deter bad behavior is to increase penalties, but then you won't help us deter bad behavior when it comes to negligent hire and supervision by government actors, make that make sense. When you say the only remedy for injured Nebraskans is to go after the individual, they don't make any money and they most likely will be in jail, i.e. they will be essentially judgment proof. So how is that going to provide justice? How is that going to cover the bills for counseling? How is that going to cover the bills for lost wages, for death, for uncovered medical expenses? The solutions that you lift up are illusory and not real solutions. That is why Senator Dungin, myself, Senator Holcroft, Senator Halloran, and others on the Judiciary Committee are trying to reset the scales of justice to tip
Senator.
towards the favor of citizens and away from big government. Thank you, Madam President.
Thank you, Senator Conrad. Senator Brandt, you're recognized.
Thank you, Madam President. I'm not quite sure where I come down on AM 3196. Would Senator Wayne be available for a question?
Senator Wayne, will you yield?
Yes.
Senator Wayne, it's pretty obvious if a state law enforcement official takes advantage of a child on shift, that would be covered. But what happens when
Actually, it would not be covered.
it
but
would
go ahead.
not, it would not be covered? That's, okay. So then my question is, they clock out, drive home, still in uniform, and assault the kid next door.
So what would happen is the plaintiff bears the burden of proving that the state is a necessary party. So when you sue somebody, it would be sue Justin Wayne and the state of Nebraska. Those would be listed as two. So the first thing that state of Nebraska would do was say, file a motion to dismiss for a more definite statement. And that statement would probably be around, put some facts in there that what happened was related to his employment. So there has to be some causal connection between the state employee, so either on duty or part of his responsibilities to engage in that. So there would have to be there, but I have no problem putting in more language to clarify that. We just had that issue with Senator Holcroft's bill. He added some more language, so I have no problem doing that.
And this just applies to police, or it also applies to first responders, firefighters?
It would respond to any state employee or political and subdivision employee. So counties, cities, state, yeah.
So it isn't necessarily just police, it could be a maintenance guy or an electrician for a city?
Correct. Or a teacher.
Okay, so now we're getting into the schools. So in the schools then, it would be any school employee or just a teacher?
It would be any school employee, but again, they are capped at $1 million. So the most you can recover from a political subdivision is $1 million. The state, it's not capped.
So, I mean, it could be a maintenance man, a bus driver, anybody employed by the school district?
Correct. And you would have to, again, prove that it was somehow related to the connection to their employee, and that the political subdivision had some type of duty in that regard. It isn't just a free-for-all.
Do you have any history of the last 10 years, 5 years? How many of these incidences occurred in the state of Nebraska?
What I would do is ask Senator Reapy to pull up the last 10 years of state claims, and that'll tell you how many people we've settled those claims with.
But that was claims. Do we know how many other ones are out there?
I don't know, because I'm assuming if they prove their case, there'd be a state claim that we would have to have voted on if it's over 50,000.
All right. Thank you, Senator Wayne. I yield back to the chair.
Thank you, Senator Wayne and Brandt. Senator Clements, you're recognized.
Thank you, Madam President. Just wanted to refer back to this as an appropriation bill. Rule 8 on page 55 of the rules talks about the appropriations process, and it says appropriation bills shall consist of the following: a mainline budget, a deficit bill, capital construction, funds transfers, cash reserves, judges' salaries, followed by bills providing for approval or disapproval of claims against the state. And so it's this is, I am claiming that it's not appropriate to put this amendment 3196 into an appropriation bill, and so I'm opposed to AM 3196, but I would yield Senator Wayne time.
Senator Wayne, you're yielded 3 minutes, 53 seconds.
Thank you, Mr. President. Thank you for your debate. I'm going to go back and tighten up this bill a little bit, and I'm going to work with Senator Holler and Senator Brandt on some of the issues that were raised. I just want to say this, though. If we're going to go down the path that Senator Clements said, because I've been actually arguing this, and me and Senator Clements agree on this, because if you'll recall last year, he tried to re-reference multiple bills back to the original committees of jurisdiction, which I thank him for. Then we need to, on final reading, have some amendments to pull things back out of the budget, because there are a lot of statutorial changes in our budget. A lot. So we have to decide what we're going to do here. But nevertheless, with that, I will withdraw AM 3196, and it'll be back up on select or on another vehicle. Thank you, Mr. President. Madam President.
So ordered. Mr. Clerk.
I have nothing further on the bill, Madam Clerk.
Returning to the queue, Senator Hunt, you're recognized.
Thank you, Madam President. Not being here this morning, not being able to be here until the afternoon debate today, I did expect Dr. Corsi, and it's hard to say Dr. Corsi because he got his PhD from what we call a degree mill, which is basically an illegitimate institution where you can kind of pay for a degree. And that might be something that I consider doing here. And then maybe I can get some kind of salary from the state, some kind of job security, some kind of title when I'm no longer a senator that would make people give me some extra respect. And, you know, maybe then that extra respect would allow me to kind of put my hands into different cookie jars funded by taxpayers and double dip and take numerous salaries funded by taxpayers, as Steve Corsi has done in his previous places of employment. But one of the things that troubled me most about his confirmation hearing was his vehement insistence that his opinions about gay people, his opinions about race, were not going to have any impact whatsoever on his ability to lead the largest code agency in Nebraska, which serves a diverse constituency of both employees and residents of Nebraska who rely on unbiased, non-judgmental, evidence-based, you know, sober, serious service from HHS as a state agency that takes their concerns seriously. There's no reason to think that that could even be true. None of us could ever stand up seriously as serious, honest people and say something like, my personal values, my beliefs, my deeply held convictions, many of which are based in religious belief, in my own faith, which none of you would stand up and deny your faith, me included. None of you could seriously say, Mr. Steve Corsi included, that they could stand up and deny that. But he did that on the record in the confirmation hearing for his application for this little job that he thinks he's entitled to, and that all of you do too. He said, I will deny my values, I will deny my ethics and my faith so that I can serve the people of Nebraska without bias and judgment. We know that he's not going to do that. Saying something like, my opinion about the homosexual lifestyle will not have any bearing on how I treat my employees who are LGBTQ. In the year 2024, you know, I know we've got conservative colleagues in here who have gay kids, who've got, you know, you all know someone gay. You all work with gay people in here. Come on. In 2024, we're really talking about homosexuality as an opinion? That this inherent thing about someone can just be the same thing as an opinion that you disagree with? That alone to me is disqualifying. And Senator Michaela Cavanaugh was very, well, what's the word? Optimistic might be too generous, but she was very prepared in creating this executive summary and this binder and spending a significant amount of time researching the background and experience of Steve Corsi so that all of you could seriously consider it before casting your vote to confirm him. And you see by the vote count this morning, there was not a cloture-proof majority up there. If that was the vote, if we had reached cloture, thank you, Madam Chair. If that was the vote when we had reached cloture, he would not be the head of HHS right now. But again, in circumventing the opportunity we have for checks and balances, in kicking the responsibility from the legislative branch back to the executive branch, which is run by one of your good friends, we lost an opportunity for the oversight and the checks and balances that are important to make sure the people of Nebraska are served. And I'm going to speak a few more times about this matter because I think that my constituents need to know that this was not necessarily rubber stamped by everybody. I I had a phone conversation, I'm going to talk about this on my next time on the mic. I'm too out of time for this
Time,
story.
Senator.
Thank you, Madam Chair.
Thank you, Senator Hunt. Senator Wayne, you're recognized. Senator Wayne waves. Senator Dungan, you're recognized.
Thank you, Madam President. Colleagues, I do rise today, I think, generally in favor of LB 1188. I was going to talk about the amendment that was on the board, but unfortunately it was withdrawn before I had a chance to get up. I still think it's worth having the conversation about it, though, to voice some of my opinions about that, given that I think my bill that we talked about a couple of weeks ago, as well as it was mentioned here today, got brought up as a part of that conversation. I absolutely agree with Senator Wayne and Senators Conrad that we need to address the political Subdivision Torts Claim Act in a substantive and holistic way. I introduced an interim study today to do a deeper dive into our laws pertaining to when we can and can't hold the state accountable. One of the things that I think became really obvious during the conversation that we had a couple weeks ago when those bills came up, I think 175, as well as a couple of other bills with myself and then also Senator Halloran, was that there are a mishmash of cases that have been ruled on by our Nebraska Supreme Court that have created this, I think, unintended consequence of not being able to hold the state accountable when either their own actors harm somebody through negligence, or when somebody they're entrusted to take care of or entrusted to be in charge of then commits a harm to somebody else via negligence as well. And so we need to address this. There are countless scenarios that we can come up with, or that I can come up with, to give you a good example of why these current laws don't work and what the problems are. I'm not going to belabor those points here today. I don't think we need to hear about all of the different really horrific situations that have arisen and will continue to arise if we don't solve this problem. But I just want to highlight for my colleagues the importance of this conversation. My hope is that through this interim study between now and the next session, we'll have an opportunity to get stakeholders together, get colleagues in the room, and talk to folks about what these problems are so we can make sure that we're actually addressing the underlying problems. It sounded like to me during the conversation that we were having on the floor a while back about, for example, extending the statute of limitation against third-party entities who are responsible through negligence for sexual assault of a child, that there really is universal support for those ideas. There's just a lot of concerns about potential consequences, and it sounded like people wanted to make sure we approached it in a deliberate manner. So my hope through this interim study and through conversations is we can approach it in a deliberate manner, but we can do so in a way that does address the underlying problems, which is that right now, colleagues, there is a lack of accountability against the state when they do something they shouldn't do. And I think that's something we can all agree on. If for example, a student is entrusted to a school and the school doesn't act and then something bad happens to that student, we want to make sure that there's accountability there. Because without accountability, there's not going to be any change. And we've seen this in our prison system, and we've seen this in the Department of Corrections, where there continues to be circumstances where harm is coming to individuals, but by virtue of the fact that there's no accountability, no change is happening. And so without that sort of impetus, I just have concerns that we're not going to actually see the actors who are in charge of this start to actually make a change. So I do appreciate Senator Wayne's conversation about this. My hope is that we can maybe potentially find another vehicle for Senator Halloran's bill, or potentially maybe one of my other bills as well, that address these problems, because I do think it's really vital we have these conversations sooner than later. But in the event that we cannot find those avenues, colleagues, I do intend to come back next year and continue to fight for those people right now whose voices are not being heard. So I hope we can continue that conversation, and I look forward to hearing more about 1188 from others. Thank you, Madam President.
Thank you, Senator Dungan. Senator Michaela Cavanaugh, you're recognized.
Thank you, Madam President. Colleagues, I was asked about the contract with Epiphany, and I don't have a lot of details about it. It being a no-bid contract means that there inherently aren't many details about it. No bid means just that, no bid. They just decided who to have. What I do know is that Epiphany worked in Wyoming and worked in Missouri and worked in Texas, and then worked for an association of cities in, I think it was Indiana. And that Association of Cities on their board has has the president or head director CEO of HDR. And then they worked for the Knights of Exarban's, in which the same individual serves on the board at the Knight of Exarban's, as does Governor Pillen. And so I don't know if that's how they came to be. That's just the connection that I have found. But additionally, I have found that they had some involvement in Utah with Nomi Health, which many of you may recall was the no bid contract for testing here in Nebraska for Test Nebraska that happened in 2020. So, and they were rife with a lot of controversy that still definitely needs looking into, but maybe they came to us through Nomi Health and that no bid contract. I'm not sure how we got to Epiphany. That is a question for the governor directly. I just know that we gave a company a $10 million contract when clearly their work history indicates that they've never had a state contract over $20,000. And additionally, the owner, executive director, CEO of Epiphany, Kristen Cox, was also accused of financial malfeasance when she worked for the state of Epiphany, or the state of Utah, and launched Epiphany. And the state of Utah conducted their own performance audit on her work, the same work that she is now applying here in Nebraska. And here's a spoiler, it didn't go well. It did not go well. I know we all want to believe that we can do more with less. But the idea, the notion that the Department of Health and Human Services is going to cut costs so significantly that it's worth spending $10 million on an unproven, untested, unvetted consultant is a little bananas to me. We cannot go through St. Francis Ministries again. They gave us the same promise. We can deliver more for less. You have in statute caseworker ratios, a human resource, a fixed cost. We can do it for 97% less. This is what we are dealing with again. And voting for Dr. Corsi this morning is an indicator that we are okay with that. That we are okay with entering into, again, a situation that is going to lead us down a path that's going to cost us more money. It's going to harm children.
1 minute.
And we're engaging with a company that, frankly, has no business getting a $10 million contract from our state. They've never even had a $1 million contract. How many employees work for this company? So far, it seems like maybe 2. How is this going to work? And what are we going to do about it? Are we going to stand by and let it happen? It looks like we're going to stand by and let it happen, which is very disappointing. Thank you, Madam President.
Thank you, Senator Michaela Cavanaugh. Senator Hunt, you're recognized.
Thank you, Madam President. My view on all this stuff that used to really get me wrapped around the axle in here is that we are all who the voters chose. We were all elected. And so, it's your state. It's your state to take care of, or to mess up, or to corrupt, or to do whatever you want with your votes. But I think from conversations I have with you personally, that's not a responsibility that you take personally, or that you take seriously. But, the responsibility exists either way, whether you take it seriously or not. And Senator Cavanaugh, all of the things that she and her office compiled for this binder, all of the things that she's been saying today on the record, whether it's about, the financial irresponsibility of Steve Corsi and his past and the kind of murkiness surrounding him, or whether it's about the moral and ethical problems with his service. These things are being said obviously not for your benefit, because if you wanted to take these things seriously, if you really wanted to run the state like a business, like many of you say, you would have been a no vote on this. If you wanted to, you would. That's the position we're in. If you guys wanted to, you would have not voted for him. So the things that she's compiled and the things that Senator Kavanaugh is saying at this point are for the benefit of the voters, for the benefit of the people watching and listening, and for the benefit of the press, who has done a really great job covering the appointment of Steve Corsi from the day he was suggested by the governor. In a story published by the Journal-Star this afternoon, they get into it a little bit, and there's much more in-depth reporting on this that I actually believe most of you know and most of you have read. I don't think that you're ignorant about this. I think you're well aware, and I think you love it, like it, voted for him anyway. And again, that's fine. This is what the voters chose. These are the outcomes we have because of elections. So, so that's how it is. But in the Journal-Star today, they reported, in Missouri, for example, Corsi was receiving paychecks from 2 departments within the state. Despite pledging to rectify the situation, he continued to receive those payments until the Jefferson City News Tribune brought it to his attention. Corsi was later the director of the Wyoming Department of Family Services when it purchased a restraint chair for the state boys' school. Now, I don't think this point has perhaps been made. What's so wrong about the chair? I know some of you hit your kids when they were little. What's so wrong about a restraint chair? The chair, the article continues, a high-back chair with a shoulder, lap, wrist, and ankle straps, received criticism when it was used at Guantanamo Bay in the torture and force feeding of children. So Corsi's department bought a freaking waterboarding chair for the boys' school. And again, I mean, clearly that's something most of you are fine with. And that's fine. Then be fine with it. The voters chose you. You get to be fine with it. But let it be said so that the voters know for next time, that's what you all voted for. The article continues, according to the Gillette News record, Corsi claimed to be not aware of the chair, not aware the chair had been purchased and used during his tenure within the department. Senator Frederickson pointed out correctly that that cannot be true because at the time in Missouri, or where was this, Wyoming, Nebraska, where is it that he screwed up this time? This one was Missouri, or it was Wyoming. It was a huge scandal at the time. It was a scandal at the time. So he was certainly aware of it. And for him to say he wasn't aware of it is a LIE lie, which is not Christian. And Corsi had liked or shared several posts on social media in recent years, calling race preposterous nonsense, downplaying slavery, and expressing opposition to same-sex marriages. I really think that Steve Corsi shares a view that a lot of you hold, which is we shouldn't let race impact the way we treat people. I think most of you think that, and I think Steve Corsi thinks that. But to say something like he has shared on social media, like he shared in the confirmation hearing, the problem with that viewpoint is that we do have racial-based outcomes for the services that we provide in Nebraska. We can see the maternal mortality rate, for example, is so much higher for Black women in Nebraska. So to say that, that's one example. So to say that you don't see race in the service we provide to Nebraskans ignores the disparities that are very real.
Senator.
Thank you, Madam President.
Thank you, Senator Hunt. Senator Michaela Kavanaugh, you're recognized.
Thank you, Madam President. So I did share in the binder an article about Epiphany, and I even went so far as to highlight parts that I thought might be of interest to you colleagues. And this is about really the start of this company. So there's concerns wonder whether Cox has been leveraging her massive TOC, which is theory of constraint experiment, for her own personal gain through private consulting businesses she owns. She has there's close ties between Cox and Goldratt, who is the person that founded this concept that appear to have created an incentive for state agencies to contract with the company. Two former state managers said having the firm as an ally seemed advantageous when budget season rolled around, potentially offering department heads a leg up as they asked Cox office for money. Both managers spoke on the condition of anonymity. That is a hard word to say. Let's see here. She does make money as a management consultant in the theories she's become known for practicing. Cox's Twitter profile identifies her as a TOC expert. As recently as May, her LinkedIn resume described her as the founder and CEO of a small consulting firm with world-class expertise in applying the theory of constraint to government, although that entry has since been removed. This was while she was employed for the state of Utah. Despite heavy advertising, individuals with a state email address made up 709 of the 1,138 attendees at last year's Utah Ops. Utah agency pay a discount registration cost, $199 per employee, out of their own budgets. Between that and the annual government budget of $70,000 to $80,000, the conference cost the state at least $210,000 last year. Prior to doing this conference on the theory of constraint, the exact same conference cost about $15,000. And I will say that at that conference, the state of Utah purchased for every attendee her book that she co-authored with Goldratt. So when you say that she's the smartest woman you know, she is certainly smart at making money and smart at getting money from the state of Nebraska without any credentials or proof that she has the ability to cut our budget by millions of dollars, but not hurt the services that the state provides. There is zero evidence of that. So, I mean, I encourage you all to read the articles, but again, you want to be willfully ignorant of the deficits of these two individuals who basically came to us together. So that's for you. Senator Hunt is correct about the chair. And I go back to Geneva. And I know so many of you were not here when the crisis happened at the Girls Youth Rehabilitation Treatment Center in Geneva, but many of you were, and many of you remember. And many of you remember touring that facility and walking through there, and the ceiling was on the floor. And there were people who were inhabiting it like that. There were youth entrusted to our state who were inhabiting it in that condition.
1 minute.
So I am fearful when I see a pattern of behavior such as not knowing about a restraint chair at a youth center. I am concerned about the youth that are in the care of this state. And I'm further concerned because so many of those youth are minorities and so many of those youth are queer, and the person tasked with being in charge of all of it has stated very clearly that he does not believe race is a thing and is very anti-LGBTQ. This is not good for Nebraska. This does not set us up for success with loving, caring people at the helm. Somebody that would outwardly spout the vitriol that has been shared publicly from this man should be concerning. And it should not be partisan.
Time, Senator.
Thank you.
Thank you, Senator Michaela Cavanaugh. Senator Hunt, you're recognized, and this is your third opportunity.
Thank you for the opportunity, Madam Chair. Okay, one other thing I wanted to make. One other point I wanted to make was about this idea of honesty and transparency and trust and all of the things that conservatives say that they feel when they talk to a fellow conservative who supports things like child abuse, supports things like denying that race exists or that LGBTQ people are loved by God, for example, which is something he does not think. So that may be a reason that some of you do have this affinity with him, because I know these are views that you share. And maybe meeting someone like that makes you trust them because you know that you share these views. For me, the stuff on the social media was enough that we should have said no. But then there was the restraint chair. Then there was the double dipping into the finances that the taxpayers were paying him. It's just one thing after another. But for me, the social media stuff would have been enough to stop. And by the way, some of you have been here for a while will remember that in the past, we have had confirmation hearings and we've had people up for confirmation who we did not approve because of things they posted on social media. In the government committee, I won't say the name of the guy because either he wasn't approved or he withdrew his name. I don't remember how it happened, but I did find extremely racist things that he posted on Facebook. And I shared these things with the committee. I distributed them on the floor. I was gonna light him up for it. And either he wasn't, Senator Brewer would remember because we got in an argument about it, but either he wasn't confirmed or he withdrew his name, I don't recall. But it used to be something that we would commonly do here. It used to be, a lot more acceptable to look at someone's qualifications and then have the legislature say, this isn't the guy. This ain't the guy. And I think that because Steve Corsi has had so much spotlight on him, maybe, that people who support him have become more and more entrenched and more insistent that we do confirm him, perhaps because of a pride issue or something like that. They don't want to have to backtrack and say maybe we were wrong. But the social media stuff was enough for me, period. In this legislature, rule changes have been introduced. There's been talk of creating social media policies in the legislature, specifically targeted at Senator Hunt, at me, because of things that I post on Twitter and on social media, criticizing many of you directly, by name, explicitly, clearly, for things that you do in public. And I think for me, that's appropriate. For me, the right way to address something you say in public that I take issue with is to do it in public. And that, to me, is the difference between something like what I do on social media that you don't like on Twitter and something that someone like Steve Corsi does on social media that I don't like, is that when I do it with my full chest. I say, this is what my colleague did and this is why I don't like it. Or I say, I think you're dumb. Or I say, I think you were stupid for this. I've said things like this. And I agree it wasn't nice or professional, but I agree that I said it and I don't regret saying it. Steve Corsi, on the other hand, he can't say any of these things with his full chest. What are some things that he's shared? How about this? There is love that's not acceptable to God. Same-sex love does not bring glory to God and does not come from God. How about this one? This is ridiculous. Stand flat-footed and speak the truth on the issue of homosexuality. Don't just look someone in the eye when God says they are in jeopardy of eternity in hell and merely wink and nod at their sin because you're afraid of being called names. Speak the truth. Does Steve Corsi stand flat-footed and speak the truth? Does he come up to me to my face and say, you're in danger of going to hell, you need to renounce homosexuality? No, he makes his Twitter private and refuses to meet with me without his posse with him. So Senator Ben Hansen, how is that transparent, honest, trustworthy, clear, whatever other values that you share with this man that makes you think that it's a good idea to confirm him? He doesn't stand flat-footed. He rejects his own faith by turning his back on his own values because he won't confront me about it. He won't talk to me to my face without all of his little helpers with him. To me, he's a coward.
Time, Senator.
Thank you.
Thank you, Senator Hunt. Senator Michaela Cavanaugh, you're recognized, and this is your third opportunity.
Thank you, Madam President. I appreciate Senator Hunt engaging in this topic because it really seemed like people were starting to at the end of the morning, but then debate got cut off. And I think that is unfortunate because so many people did not engage. Very few of the 28 people who voted for him spoke. I can't think of more than 2 actually who spoke. And I'm going to keep bringing this back to a known entity, St. Francis Ministries. Now, Senator John Kavanaugh said that people didn't really acknowledge at that time. I was a freshman, and it was 2019, and it was the end of session, and the administration announced that they were not renewing, it was June, not renewing their contract with Promise Ship, which had had the contract for several years. They were moving forward with a new company called St. Francis Ministries. And I was immediately concerned, but also didn't understand things as well as I do now. And so I started asking questions. And I will say that people were shocked that the contract was not awarded to Promise Ship, but was moved to a different organization. And people did have concerns over the cost, because we had just done a cost analysis from an outside consultant that said that we could not do the work for less that Promise Ship was doing. That what Promise Ship was charging the state to do the child welfare work they were doing was very reasonable, and the state would have a difficult time doing it for less. And then we entered into a contract that was 40% less than that. And not only 40% less than that, and I got this number wrong before, but the administrative costs, the people, the human resources, was 93, not 97, 93% less. And do you know who figured that out? I figured that out. I sought out the attorney from Promise Ship who was suing St. Francis Ministries. I looked through those materials. I requested additional materials. I did my due diligence. And for some reason, I still don't have street cred with you all. You will not listen to me. You always want to learn things the hard, expensive way. I take this seriously. I take it seriously to try to obstruct a gubernatorial appointment because I think the governor should have who he wants, but I also believe we have the process for a reason, and that is to protect Nebraskans, to protect taxpayer dollars. Yet you still have zero confidence in me. I genuinely think there is nothing I could do or say to get any of you to change your vote. It was set in stone. You don't care. You're not interested in listening to facts and evidence.
1 minute.
It is so disappointing that no one asked any questions. No one engaged in this conversation or this debate. I have done my homework on this and on previous occasions. I brought an entire legislature along, an executive board, a speaker, a chair of the executive board, to install a special investigative oversight committee with subpoena power to look into St. Francis Ministries. I did that. And you still don't have any confidence in what I put in front of you. No deference whatsoever. I have saved the state from itself. And I am trying to save the state from itself again. And I know that Senator Hunt filed a motion to reconsider, which we could take up or we could not take up. But if you
Senator.
all, thank you.
Thank you, Senator Michaela Kavanaugh. Seeing no one else in the queue, Senator Riepe, you are welcome to close on LB 1188. Senator Riepe waives closing. The question before the body is the advancement to ENR initial of LB 1188. All those in favor vote aye. All those opposed vote nay. Have you all voted who care to? Record, Mr. Clerk.
40 yeas, no nays in advancement of the bill, Madam President.
The bill is advanced. Mr. Speaker, for an announcement.
Thank you, Madam President. So in a moment, I intend to make a motion to expedite LB 1188. Prior to making that motion, I want to explain what it means to those in the body who are unfamiliar with the motion. It is strictly a procedural issue that we have here. Traditionally, and now by rule, the state claims bill follows the budget bills at each stage of debate. This year, due to late claims, we have just held the general file debate of the claims bill and have advanced the bill to E&R initial, or will about to advance the bill. It's my intention to schedule LB 1188 on select file tomorrow in order to at least allow the bill to be read on final reading during the same week the budget bills are read, which will be Tuesday morning. To allow for select file of LB 1188 tomorrow, the revisor's office will need to review the bill at E&R initial prior to other bills that are being reviewed. The policy of the revisor's office is to review bills in the order they are received, except for the budget bills, which are automatically expedited. So a motion to expedite LB 1188 allows the revisor's office to review this bill immediately and return it to us by tomorrow for select file. So I'm assuming that motion will be made after the passing of LB 1188. Thank you, Madam President.
Without objection, so ordered. Mr. Clerk, for items.
Madam President, new A bill, Legislative Bill 348A, introduced by Senator Wayne's bill for enacting relating to appropriations, appropriates funds aid in the care of the provision, Legislative Bill 348. LB 1126A, introduced by Senator Boston's bill for enacting relating to appropriations, appropriates funds aid in the care of the provisions, Legislative Bill 1126. New A bill 1200A, introduced by Senator Mosier's bill for enacting relating to appropriations, amend section 64 and 65, reduce appropriation to aid in the care of the provision, Legislative Bill 1200, and repeal the original sections, declare an emergency. Legislative Bill 196A, introduced by Senator McDonald's bill for enacting relating to appropriations, appropriate funds to aid in the care of the other provision, Legislative Bill 196, and declare an emergency. Legislative Bill 1356A, introduced by Senator Wayne's bill for enacting relating to appropriations, appropriate funds to aid in the care of the provision, Legislative Bill 1356. LB 1067, introduced by Senator Clement's bill for enacting relating to appropriations, appropriate funds to aid in the care of the provision, Legislative Bill 1067, declare an emergency. Legislative Bill 1027A, introduced by Senator Clement's bill for enacting relating to appropriations, appropriate funds to aid in the care of the provision, Legislative Bill 1027. New LR 356 from Senator Von Giller, then it'll be referred to the Executive Board. LR 357 from Senator Holcroft, referred to the Executive Board. Senator Slama, LR 358. That will be referred to the Executive Board. LR 359 from Senator McKinney. That will be referred to the Executive Board. LR 360 from Senator McKinney, also referred to the Executive Board. LR 361 from Senator Michaela Cavanaugh, referred to the Executive Board. LR 362 from Senator Brewer, referred to the Executive Board. LR 363 from Senator Brewer, referred to the Executive Board. LR 364 from Senator Brewer, referred to the Executive Board. LR 365 from Senator Day, referred to the Executive Board. LR 366, 367, both from Senator Day, as well as 368, 369, 370, 371, 372, all referred to the Executive Board. LR 373 from Senator Ibar, referred to the Executive Board, as well as LR 374, 375, LR 376 from Senator Mosier, referred to the Executive Board. Notice LR 377 from Senator Von Gillen, referred to the Executive Board. Notice committee hearing from the General Affairs Committee. That's all I have this time, Madam President.
Thank you, Mr. Clerk. We'll proceed to select file LB 1355. Mr. Clerk.
Madam President, Legislative Bill 1355, select file. First of all, Senator, there are E&R amendments.
Senator Ballard for motion.
Madam President, I move that the E&R amendments to LB 1355 be adopted.
Colleagues, the question is the adoption of the E&R amendments to LB 1355. All those in favor say aye. All those opposed say nay. The amendments are adopted.
Madam President, concerning LB 1355, Senator Vargas, I have AM 3107 with a note you wish to withdraw.
So ordered.
Madam President, in that case, let Senator Vargas move to amend with AM 3194.
Senator Vargas, you are recognized to open on AM 3194.
Thank you very much. And thank you for all those LRs that just got referenced to our executive board. We got a lot more work. Good afternoon, colleagues. I'm bringing you LB 1355 with Amendment 3194 overall, and I want to thank everyone for supporting this bill. This is an opioid recovery fund update to address our serious public health concerns stemming from the rapid increase of prescription and non-prescription opioid drugs by establishing aid programming. I also want to thank you all for advancing this earlier in general file without opposition. I know that we all feel the gravity of this issue. I'm grateful for your support in moving this bill forward. I also want to continue to thank Chairperson Hansen, our fiscal analysts, dedicated staff in bill drafting, PRO, and everyone else on DHHS with their help with the amendment process. LB 1355 and this amendment 3194 has been a lot of work, not only from our office, but also from Director Green and his staff in the governor's office, and efforts from our legislative fiscal office to make sure that we are doing everything so that it both works and is operational. A shared vision for how we can make the lives of Nebraskans safer and healthier made compromise possible. I was inspired to draft LB 1355 after witnessing roadblocks experienced from actually getting funds out to the community. The work through the Opioid Remediation Advisory Committee actually had some recommendations for use of the monies, and these aid programs are based on those recommendations. But largely, this 3194 is the result of a couple of different compromises. Amendment 3194 includes language that now details that the behavioral health regions will administer direct and receive direct aid outlined in this and will administer programs directly. Amendment 3194 also includes more specific language to set aside funds not only for remediation and treatment and prevention, but also infrastructure projects. We had a lot of conversations with the governor's office about the need to want to do future infrastructure projects with opioid funds related to drug treatment and drug rehabilitation. And we want to make sure we have funds for that. So we're setting aside and creating an infrastructure opioid grant fund, opioid fund to be able to save dollars for the future for that. We've also included funding for critical necessary research being done at the University of Nebraska Medical Center on opioid remediation, prevention, and treatment. In 2022, 175 Nebraskans died of a drug overdose. Of those 175 deaths, 60% cases had at least one potential opportunity for intervention. The statistic stands out when we really truly think about the human cost of not getting these dollars out. In the United States, 81.8% of all overdose deaths involved at least one opioid. In Nebraska, 67% of all overdose deaths involved opioids. Illegally made fentanyl was the top opioid involved in both cases. Now, LB 1355 also includes Senator Ballard's LB 1320, which would require any emergency medical service that treats or transports a person experiencing a suspected or actual overdose to report the incident to DHHS within 72 hours when possible. LB 1355 and 1320 were heard in committee without opposition and were voted out of the Health and Human Services Committee 8-0. I appreciate Senator Hansen and all the work he's put into it. A couple other additions in terms of what the amendment also does. It also includes a clawback portion. So if the dollars that are actually being provided to behavioral health regions will be clawed back if they're not used within 2 years to the opioid aid cash fund. There's also reporting requirements to make sure that we are monitoring the use of these funds. Again, this is all cash funds. And I want to thank you all for all your support in this work. Thank you again to the committee and for those that have been alongside me in this fight, both previously, and just want to encourage your green vote on LB 1355 and Amendment 3194. Thank you.
Thank you, Senator Vargas. Mr. Clerk, for an amendment to the amendment.
Thank you, Madam President. Senator Vargas would move to amend with FA 312.
Senator Vargas, you are recognized to open on floor amendment 312.
Thank you very much. So as I mentioned earlier, really high level. One, This continues to make sure that dollars are used and are getting out. It's creating an opioid aid fund and an opioid infrastructure fund. The opioid aid fund will receive about $3 million every year from the opioid settlement funds. This will get out directly to the behavioral health regions so that they can address immediate concerns regionally, and it provides a little bit more autonomy and flexibility for them to do what is necessary locally, and also allows us to save and set aside funds for opioid infrastructure, which allows the state to think about future projects that can be utilized to address the opioid epidemic across the state and also locally and regionally. So that's the major changes in this. So it operationalizes, it creates those 2/8 cash funds, creates accountability, and also creates reporting. And I ask for your green vote on 3195, and the amendment 312 is a small technical amendment change that was asked from DHHS to make this operational. Thank you.
Thank you, Senator Vargas. Turning to the queue, Senator Conrad, you're recognized.
Thank you, Madam President. Good afternoon, colleagues. I just wanted to reaffirm some longstanding concerns I've had about the state's utilization of settlement funds. I wanted to note for the record that I do have a bill that carried over from last year that's still pending before the executive committee in regards to ensuring greater transparency, oversight, and clear appropriations power for state settlement funds by the Nebraska Legislature, consistent with our powers of the purse and our sole appropriations prerogatives. I also have expressed concerns about how these opioid settlement funds are coming into the state, kind of what the current status is. I know Senator Vargas and others have worked really hard to try and make sure that these settlement funds are going to be utilized to their best and highest purposes. But I do want to reiterate, I do feel that Nebraska is behind the curve already when it comes to this issue. Many of our sister states have acted more expeditiously to push these dollars out to the front lines for treatment and services as they were intended to. I'm concerned that our settlement dollars are being frittered away by high-priced consultants, and very few of these dollars are really moving out to the front lines. Hopefully, what Senator Vargas is trying to do here will make a positive difference to expedite the utilization of these funds. But I do want to note that we should be very, very careful and thoughtful not to cede any of our appropriations authority. And I'm going to think more deeply about how this measure is structured, perhaps today or in between today and final reading. But I'm uncomfortable with giving some sort of open-ended grant of authority to the Department of Health and Human Services or the advisory committee or whoever it might be. These funds need to be subject to appropriations as all public funds are. And I'm not sure if there's enough guardrails here. But if anybody has a sense from Senator Hansen, who I know works a lot on these issues as chair of HHS, or Senator Vargas or members of the Appropriations Committee, I think it would be instructive to the body to know how much has Nebraska received in this settlement? How much have we paid out to who? What's remaining, and what's the plan for what's remaining? I think that would definitely be appreciated. Also getting some sort of clarity about how these funds may or may not be utilized to address some of the funding cuts to behavioral health that were subject to the budget, how some of these program activities interface with what's happening at the healthcare cash fund or other HHS related activities, how and if these dollars should be invested in not only treatment and services for behavioral health and drug treatment, but problem solving courts as well, which we know has been something that our sister states have looked at for these issues. And we know that we have before us with Senator Wayne's effort and Senator Brewer's effort on veterans courts. We need to make sure that we're scaling up those kinds of efforts across the state because they ensure better outcomes for participants and for taxpayers. So there's some restriction on to how these settlement funds can be utilized, but I want to make sure they're being utilized for their best and highest purposes. I want to make sure they remain subject to appropriation, and I think the body would be well served to have more details in regards to this settlement fund. Thank you, Madam President.
Thank you, Senator Conrad. Senator Hansen, you're recognized.
Thank you, Madam President. I first want to say thanks to Senator Vargas for taking on this task of the opioid settlement funds. I know him and I had similar bills when we first started. I didn't end up introducing mine. And so I think he's done a great job working with the department and other senators, our committee, about making sure that the funds are directed appropriately, what they were actually originally settled for. And also, I kind of like some of the forward thinking that we see from Senator Vargas, what's in the bill, and the department about the infrastructure portion of this bill. Like some of this money can then be used eventually down the road for possibly another facility to help those who are addicted to opioids, actually have some programming, actually help them kind of get over their problems. So I think it's a dual effort here, I think, of taking care of those currently who are addicted and maybe even making sure that we can keep it out of the hands of those who potentially could be. So I will be voting green on the floor amendment and the LB 1355 and the amendments below. So I encourage my colleagues to do the same. And again, thanks, Senator Vargas, for putting all this together. Thank you, Madam President.
Thank you, Senator Hansen. Senator Ballard, you're recognized.
Thank you, Madam President. I'd just like to echo Chairman Hansen's words and thank Senator Vargas for his hard work on this legislation. I do rise in support of AM 3194 and LB 1355. This is a well-balanced attempt to legislate both prevention and also treatment. So I think it's a step forward, a right step forward in the tackling the opioid crisis in Nebraska and the United States at large. So thank you, Madam President.
Thank you, Senator Ballard. Seeing no one else in the queue, Senator Vargas, you are welcome to close on Floor Amendment 312.
Floor Amendment 312, again, is a simple technical change. I urge your green vote. This is brought to me from HHS. I urge your green vote on this floor amendment. Thank you.
Thank you, Senator Vargas. The question before the body is the adoption of Floor Amendment 312 to AM 3194. All those in favor vote aye. All those opposed vote nay. Have you all voted who care to? Record, Mr. Clerk.
40 yeas, no nays on adoption of the floor amendment, Madam President.
It is adopted. Seeing no one else in the queue, Senator Vargas, you are welcome to close on AM 3194.
Thank you. I just want to make sure Kathleen Kauth is here. We do not want to miss, we don't want that yell happening again. So again, thank you to everybody. Thank you to everybody for your support on this both compromise amendment. And I've had a good conversation with Senator Conrad. You know, the goal of this again is to make sure some dollars are getting out. We're also setting aside some dollars for infrastructure. We're trying to address the opioid crisis in Nebraska. And we are trusting local partners and behavioral health regions, public health, and others to do the work, while also making sure our state has some flexibility to address this in the short, medium, and the long term. I urge a green vote for Amendment 3194.
Thank you, Senator Vargas. The question before the body is the adoption of AM 3194 to LB 1355. All those in favor vote aye. All those opposed vote nay. Record, Mr. Clerk.
41 ayes, no nays, on adoption of the amendment, Madam President.
The amendment is adopted. Mr. Clerk.
Madam President, Senator Boston moved to amend with AM 3153.
Senator Boson, you're recognized to open on your amendment 3153.
Thank you, Madam President. Amendment 3153 is LB 892 committee with a committee amendment. It's updates the annual Controlled Substance Act. I want to thank Senator Vargas for letting me add this on, and I would appreciate your green vote. Thank you.
Senator Conrad, for what purpose do you rise?
Point of order, germaneness.
Senator Boson, Senator Conrad, Speaker Arch, will you please approach? Senator Conrad, you're recognized.
Thank you, Madam President. I'd withdraw the point of order on germaneness.
So ordered. Senator Boson, you're recognized.
Thank you, Madam President. I would ask to pull the AM 3153.
So ordered. Mr. Clerk.
Madam President, I have nothing further on the bill.
Senator Ballard for a motion.
Madam President, I move that LB 1355 be advanced to ENR for engrossing.
Colleagues, you've heard the motion. All those in favor vote aye. Say aye. All those opposed say nay. It is advanced. Mr. Clerk for the next bill.
Madam President, next bill, Legislative Bill 1120, introduced by Senator Hardin. First of all, Senator, I have ENR amendments.
Senator Ballard for a motion.
Madam President, I move the ENR amendments to LB 1120 be adopted.
Colleagues, you've heard the motion. All those in favor say aye. All those opposed say nay. They are adopted.
Madam President, Senator Hardin would move to amend with AM 2952.
Senator Hardin, you're recognized to open on your motion.
Excuse me, Madam President. Senator Hardin, I have a note you would withdraw AM 2952. In that case, Madam President, Senator Hardin would offer AM 3029.
Senator Hardin, you're recognized to open on AM 3029.
Thank you, Madam President. AM 3029 simply ensures that land titles are marketable and insurable for a land purchase if, in the past, an affidavit was mistakenly not filed. Thank you, Madam President.
Thank you, Senator Hardin. Seeing no one else in the queue, the question before the body is the adoption of AM 3029 to LB 1120. All those in favor vote aye. All those opposed vote nay. Have you all voted who care to? Record, Mr. Clerk.
35 ayes, no nays, Madam President, on adoption of the amendment.
It is adopted. Mr. Clerk, for anything further on the bill?
Madam President, Senator, I have nothing further on the bill.
Senator Ballard for a motion.
Madam President, I move that LB 1120 be advanced to ENR for engrossing.
Colleagues, you've heard the motion. All those in favor vote aye. Say aye. All those opposed say nay. It is advanced. Mr. Clerk for the next bill.
Madam President, select file Legislative Bill 1108. First of all, Senator, there are ENR amendments.
Senator Ballard for a motion.
Madam President, I move the ENR amendments to LB 1108 be adopted.
Colleagues, you've heard the motion. All those in favor say aye. All those opposed say nay. The ENR amendments are adopted.
Madam President, Senator Dorn would move to amend with AM 2943.
Senator Dorn, you're recognized to open on AM 2943.
Thank you, Madam President. The amendment 2943 is for the emergency provider bill that we had, 1108. It's an amendment at the request of the Department of Health and Human Services to address two aspects of the bill. First, the term emergency medical responders is used in the amended version of LB 1108. This is a specific category of medical care provider. The amendment strikes that language and inserts the broader term medical care provider to harmonize with the same technology already in statute. In other words, we'd had some different language in there. It puts it back in there, so the broader language, medical care provider. The second portion of the amendment adds permissive language to allow the Department of Health and Human Services to draft rules and regulations if they need to in order to carry out the provisions of 1108. Please support AM 2943 and then advance 1108. Thank you.
See no one else in the queue. Senator Dorn, you're recognized to close on AM 2943. Senator Dorn waives closing. The question before the body is the adoption of AM 2943. All those in favor vote aye. All those opposed vote nay. Mr. Clerk, please record.
37 ayes, no nays, in adoption of the amendment, Madam President.
The amendment is adopted. Mr. Clerk, for anything further?
I have nothing further on the bill, Senator.
Senator Ballard for a motion.
Madam President, I move that LB 1108 be advanced to ENR for engrossing.
Colleagues, you've heard the motion. All those in favor say aye. All those opposed say nay. The bill is advanced. For the next bill, Mr. Clerk.
Madam President, select file legislative bill 1169. I have no ENR amendments. Senator Conrad would move to amend with AM 2944.
Senator Conrad, you are recognized to open on your amendment.
Thank you, Madam President. Good afternoon, colleagues. I stand before you as I think the lone no vote out of committee and perhaps the lone no vote on general file in regards to this legislation that's been prioritized by my friend Senator Erdman, reclassifying the state agency History Nebraska, which has, I think, for well over 100 years been organized as an independent entity to become a code agency under the direct control of the governor due to some recent issues about leadership and mismanagement, et cetera, that I know that we are all concerned about. So while sharing those concerns about what has happened in recent years at History Nebraska, Senator Erdman and I honestly just have a different remedy in mind when it comes to addressing that. He's been very clear that he thinks that will help to address issues of leadership, waste, fraud, and abuse by creating a code agency of History Nebraska, and that's what his priority bill before us this afternoon would do. I will absolutely keep my word to Senator Erdman. I told him I am, from a principled perspective, I am opposed to this measure. I don't think that this is the right remedy to address the issues that have been before History Nebraska in recent years. I also will keep my word to Senator Erdman that I will not launch a filibuster on this. I haven't filed any hostile motions to extend or structure debate. I haven't engaged in any significant conversations with colleagues other than those who asked me about my no vote on the record. So I definitely am keeping my word to Senator Erdman, and I want to flag that for the fuller body. However, friends, I did put forward a serious amendment, Amendment 2944, that I'll have an opportunity to get into a little bit more deeply, but it's a short paragraph in terms of the actual language that retains Senator Erdman's approach to make History Nebraska a code agency under direct control of the governor, but provides some protective language about how the operations of History Nebraska would be conducted. I utilized similar statutory language that helps to govern the Nebraska Arts Council to ensure a protection for free expression and for academic freedom and related issues. So there is existing precedent in our code book for protection of free expression where it is an issue for different agencies of state government like the Arts Council. These are some of the most significant concerns that have been brought forward by supporters of History Nebraska that are concerned that there is going to be a political interference in the work of History Nebraska, and this helps to ensure that the study, assemblage, maintenance, presentation of exhibits, objects, manuscripts, and other items of historical materials are performed in a manner that stimulates, encourages, and protects freedom of expression and academic freedom, essential for the appreciation and understanding of the history of Nebraska. So it is a short paragraph modeled on language from the Nebraska Arts Council that still achieves Senator Erdman's goal in reclassifying the agency, but does provide some guardrails to ensure that History Nebraska can continue to engage in their important work that they've done independently for well over 100 years without political interference in regards to content of their work, or whether or not they take part in community festivals or community engagement as they see fit, which has been a consistent undercurrent from the hearing forward. To be fair, and I know Senator Erdman will probably punch in and tell you, he does not consider this a friendly amendment. I did bring it to him with the hope that he might give it a blessing before we had to file it on select file, but he wasn't interested in pursuing it at that time, but I did give him a heads up about it many days in advance of filing it, and then did just get it filed on here today. So I think it's a very modest amendment that still achieves Senator Erdman's goal, but does provide some statutory protection for the important and unique work that happens at History Nebraska. Madam President, how much time do I have left?
4 minutes, 42 seconds.
Okay. I'm hoping that maybe I might punch in again just to talk about some broader issues that are surrounding this and other measures before the body, but I would urge your favorable consideration of this measure. Colleagues, I don't think it's right to cede oversight of History Nebraska to the governor and make it a code agency. And here's why. Please help me work through this together. This isn't about Governor Pillen. This isn't about an individual who happens to be the governor at this point in time. We can and we should enjoy a warm professional relationship whenever we can to work together with members of the executive branch, and to also hold our ground as a separate and co-equal branch of government. So this has nothing to do with Governor Pillen as a person. This has to do with the institutions between independent state agencies, the independent state legislature, and the governor's office. So I do not think that we should cede oversight and control of History Nebraska to the governor. That's why I opposed the bill in committee and on general file. But if the body is going to pass this bill and do this, I think at a minimum, we should ensure that History Nebraska fulfills its promise to the state. And they have a very, very long track record and clear commitment with donors, of artifacts, of financial donors, of other stakeholders to carry out their work in a special and unique way that includes free expression and academic freedom. My amendment would provide that the collections and historical properties of History Nebraska be maintained and ordered and made available in a way that facilitates and protects freedom of expression and academic freedom. Again, this is similar to language governing the Arts Council. You can see that at Nebraska Revised Statute Section 82-312. So this should not be novel or controversial. This will only provide a bit of additional guardrail to the governor and the appointed director that there is not improper political interference or influence on History Nebraska in a way that would limit free expression or academic freedom when telling the important history of this state and ensuring that the assets of History Nebraska are properly maintained, studied, and preserved for the people of this state outside of political interference. I'm happy to answer questions on this measure. It is a serious and modest proposal. I would appreciate your consideration of the amendment. Thank you, Madam President.
Thank you, Senator Conrad. Senator Erdman, you're recognized.
Thank you, Madam President. Good afternoon. Senator Conrad is right about one thing. She did come and speak to me about this. She's also correct on the other thing. This is not a friendly amendment, and I will go through that in a moment and explain to you why that is. But I just want to refresh your memory on why we're doing this. We're doing this because this association, this History Nebraska, has been doing things with the funding that needs to be changed, and we have an opportunity today to make a difference on how the funding is cared for and the confidence that we can place back in History Nebraska. When Senator General Lemke came in and testified, he stated several things that I thought were very important, and he said one of the things that come to his attention was the Foundation Association has a wide social network, and he has received informational feedback from both prior and current employees about the concerns about the way History Nebraska is recording history. The History Nebraska board function as it is, as he observed it for the past 3 years, is very closed and non-communicative. To be effective, it needs to be exceptionally open to the members. In 2022, the director of History Nebraska had started a fund that was a foundation called History Nebraska. That foundation was started with the help of a History Nebraska board member, Dave Levy. And so the History Nebraska board has never, ever dealt with the auditor's report or acknowledged the wrongdoing of Trevor Jones. And so also what they have is a voting element of the membership, and that program is broken. They give staff members free membership, and they encourage them to vote for the preferred board members that they want to get elected. In the past, the ballot has been organized and identify the board members preferred by the candidates, and they vote for all of them in one click. The board preferred candidate information has received preferential treatment at History Nebraska headquarters. The free voting only membership category exists, but History Nebraska's website buries it. I challenge you and your staff to try to find it on the website. So I go on to tell you about this, what happened. History Nebraska, when they started this organization called History Nebraska Foundation, the Board of Trustees they said they did not know about that, but a couple of weeks ago, when Trevor Jones was in front of the Lancaster County Court, Jones said, he further argues that the executive committee then specifically directed the defendant to deposit the money in History Nebraska's foundation account. So here we have a situation where Jones is now blaming the board for what he did. So most of the people that were on History Nebraska's foundation board are still serving on the foundation board. So now I want to speak about why Senator Conrad's bill is not needed, or amendment, excuse me. It says in the bill, if you read the bill, it says History Nebraska's headquarters and museum in Lincoln shall be used as a society headquarters. And it is for the prevention, care, research, and exhibition of research into documents, books, newspapers, weapons, tools, pictures, relics, scientific specimens, farm and factory products, and other collections pertaining to the history of Nebraska. So we already have in place exactly what she's asking us to do. And then I want to go on and talk about what the responsibility of the trustees are. It also goes on to say, in accordance with the applicable law, the powers and duties of the Board of Trustees shall be as follows. Now, these are the directions given in the bill to the Board of Trustees: to elect annually among their members a president, vice president, and second vice president, and to operate in the interest in preserving the heritage of the state and its people, and required by any state statute or any prescribed by the rule of the registration adopted by proclamate the rules of the director of the State Historical Society. So all of those things that Senator Conrad is asking to do in her amendment are already in the bill. And so I would encourage you to vote against this amendment. And if an amendment is needed, if it doesn't function correctly, you can come back in a year and make those adjustments. But unless we fix History Nebraska's malfeasance in the management of not only their finances, but all of the agency itself, we're going to continue to get what we've been getting. This is the answer: change the code agency. Thank you.
Thank you, Senator Erdman. Senator Brewer, you're recognized.
Thank you, Madam President. Well, I spoke earlier on the first round and had shared some of my concerns, mostly from the conversations and the committee hearings The comments by General Lemke and the fact that there are a few people I know that I respect more than General Lemke. And if you go back and look at the history of how we got to where we're at, the transition to History Nebraska and the 3 different incidents where there has been problems on the accountability and financial side. If you look at the issues that were brought up last time with items being destroyed that should remain part of what they keep, were concerning. But I received another note from General Lemke after we had our general file debate. And what he talked about was that the fiscal note was inaccurate. And I'm just going to read a little of what he sent to me. He said the fiscal note input from History Nebraska is incorrect. The Nebraska State Historical Society Foundation has the capacity to support it. So again, you have History Nebraska, which is more the day-to-day functional part of this. It broke off from the Nebraska State Historical Society and renamed itself, although that's not authorized in code. That was never done. And so what he's saying here is that this fiscal note, I'll run through that, said implementing LB 1169 is essential and is necessary for us to restore the donor confidence in History Nebraska. The fiscal note for LB 1169 contains an input from the Nebraska State Historical Society, History Nebraska, asserting that the private donations will diminish with the conversion to a code agency. The input also states that the agency plans on raising $1 million in contributions in the next fiscal year, which needs to be replaced by state funding. He goes into the different code numbers and how that money's raised. I won't go into that with you. My point is that General Lemke has been a part of that board through a lot of the turbulations. He understands that they have tried a number of different ways of fixing this broke agency, and they haven't been able to do it. And they're being ignored as the agency that raises the money to make it possible for History Nebraska to exist. So if we don't figure out a way of fixing the problems that we have, then we're not going to be able to raise the money. And that's his true concern, that the Nebraska State Historical Society, which has for years and years been the place where people will bring artifacts or donations, will cease to be able to do that because there's no credibility that that is going to be used the way it's meant to be used. And with the problems that we're having now and the court case on Trevor Jones, I believe that his point of not being able to have the confidence to have support necessary to continue is there if we don't have oversight. And that's what LB 1169 does. So I would just ask for your support on LB 1169. Thank you, Madam President.
Thank you, Senator Brewer. Senator John Kavanaugh, you're recognized.
Thank you, Madam President. Well, I rise in support of AM 2944. I didn't speak on this bill the last time around. I think I'd stepped out of the room when we had the vote, so I wasn't a recorded vote, but I would have been a no vote at that point in time. But I did think Senator Erdman and Senator Brewer have raised some interesting points about oversight, and I'm just kind of trying to work my way through the committee or the History Nebraska website to see what their corporate structure and governance is. But I appreciate Senator Erdman's frustration, and what Senator Brewer was talking about is that we basically need to get some control here. And I think it is kind of an interesting conversation to be having after the conversation we had this morning about exercising our role in the appointments. And I think Senator Erdman brings up a good point is there have been some problems in the administration of History Nebraska, clearly. And there's maybe not a sense of urgency to fix some of those problems. And maybe you could draw a line to the lax oversight and the slow correction to lack of oversight. And I think that's a really good example as to why folks should have taken the conversation more seriously this morning. We had a whole conversation about an agency head of an agency that has had problems from lack of oversight. And then we had concerns that were raised, and everybody just wanted to move on from them. So maybe the problems experienced at History Nebraska are akin to the problems we're experiencing at HHS, because the folks that are on the board are behaving much like the folks here on HHS, which is we want to just kind of move on from stuff and not stare directly at our flaws. And the only way you really, fix something is if you identify the problem and then start working on it. I appreciate that Senator Erdman has identified a problem and is working toward a solution. And as Senator Conrad said, I disagree with the particular solution he's proposed here, but I appreciate somebody taking seriously the work that we have before us to make sure that the state of Nebraska is being operated in all respects as best that it can. I support Senator Conrad's amendment because I think within the confines of Senator Erdman's proposal, it does make it a better bill. It certainly protects freedom in terms of intellectual discussions and proposals. I'm sure a lot of folks here have been to some of the History Nebraska holdings, we'll call them. There's the museum down here on the mall, but there's also a facility in my district where they do historic restoration, which if you haven't gone, I'd certainly encourage you to go. It's really cool. They do some really interesting, advanced type of restoration. They bring in stuff from all over the country. One time when I was there, they had a bunch of stuff from the state of Missouri, I believe it was, where they had a fire and they needed to do some rehab work on the office desks for their legislature. So other states are sending things in to have work done because of the level of expertise that we have. And one of the things that allows you to have historical, scientific, intellectual experts is by protecting intellectual freedom and ensuring that those folks are not going to be fired because whoever happens to be at the top doesn't particularly agree with what their view of some sort of issue. So I think that's a really important addition for Senator Conrad's amendment.
1 minute.
Thank you, Madam President. But I think this is a really good conversation to have. I actually have an amendment coming up later that I also consider as a friendly amendment, but I don't know how Senator Erdman will take it, but we'll talk about it. But I think looking for solutions and working together is really important, and trying to solve this pretty crucial problem. So I appreciate the work of Senator Erdman, and I'll push my light and talk about the other thought that I was going to raise because I'm going to run out of time here. Thank you, Madam President.
Thank you, Senator Kavanaugh. Senator Erdman, you're recognized.
Thank you, Madam President. So I'm going to continue to explain or describe to you why Senator Conrad's amendment is not needed. And I want to continue to talk about what the duties of the trustees are. And the duties of the trustees is to create and to aid the efficient administration of the affairs of the society. It's to advise the director of the Nebraska State Historical Society regarding the administration of the society. That's the job of the trustees. We're not taking that away. Their other job, or what they're called to do, is they shall collect and assemble and preserve, classify and exhibit the following when appropriate and according to the museum and artifactual standards: any book, pamphlet, any transcript, newspaper, photograph, business record, personal paper. Any of those things are to be kept in good shape so the history of Nebraska, so people can see the history of Nebraska. They shall ensure that the collection of these properties of the society are maintained in good order or repair. So what Senator Conrad is trying to do is already included in the bill. It's already in the bill. I'm not going to tell you to advance 2944 because it's already in the bill. Those things that she's asking to do And the first part of the bill, in section 2, it talks about the trustee shall advise the director and perform the duties specified in the statute that I just read. So all of the things that Senator Kavanaugh is trying to say her amendment does is already included in the bill. For the life of me, I don't understand what the disconnect is there. If you've read the bill, if you see what the language is in the bill, why you would introduce such an amendment that's already included in the bill makes no sense. And so what I said earlier on the mic is that this amendment is not needed. This bill completely confirms what she's trying to do in her amendment, and it is not needed. And so I would encourage you to vote against 2944 and advance 1169. The problem we're trying to solve here is the fact that the board that we currently have has been part of the problem as well. And so we need to make sure that when we have a new director, that director understands what the charge is and what they're supposed to do. And so with the advice or with the help of the trustees, they will make the decisions that are appropriate to making sure the history is kept as it should be kept. So when we have a board that has that agency has an $8 million budget, and they meet quarterly, think about that for a moment. They have 90 employees, and the staff, the director of the History of Nebraska in the past was the third highest agency director in the state. Third highest director managing 90 people. How did he get to that salary? It's because the board voted him that salary. So things are out of control at History of Nebraska, and the only way to get it back into control is have an elected official be in charge of the person who is running that agency, and it has to be confirmed by the legislature. And so what we're trying to do today is that Senator Brewer rightfully explained, we're trying to bring some confidence back, restore confidence in History of Nebraska, that people can make a contribution with their artifacts as well as their finances, and make sure that it's well cared for and it's spent on the things that they ask it to be spent on, and their history is preserved.
One minute.
This is an amendment that's not needed. I ask you again, vote red on 2944 and advance LB 1169 as presented. Thank you.
Senator Michaela Kavanaugh, you're recognized to speak.
Thank you, Mr. President. Would Senator Erdman yield to a question?
Senator Erdman, will you yield?
Yes.
Thank you, Senator Erdman. So if we were to move forward with 1169, what would be the process for naming a new director of History Nebraska?
The governor will select the new director, and he'll be that person, whether it's he or she, will be responsible to the governor.
And how is that better than having a board of trustees select?
Well, what happens now, Senator Kavanaugh, is the director is selected by the board, and the board has 3 people that are appointed by the governor and 9 people or 12 people that are elected by the History of Nebraska people. And consequently, when they select the director, that director then is responsible to them. And that's how we got into the malfeasance of the finances. And that is how we have been mismanaging History of Nebraska all this time, because there's no oversight and there's nobody they're responsible to except the board.
But as Senator John Kavanaugh pointed out this morning, we just rubber stamped a gubernatorial appointee that also had financial, what could be described as malfeasance in previous jobs, and we did nothing to address that. So I don't understand how moving this to the governor is going to fix the problem that you're trying to fix if we're just going to rubber stamp gubernatorial appointments. And there's no background check required, and there's no oversight required. There's just a public hearing.
Was that a question or a statement?
It's a question. How does this improve the process?
Well, first of all, if you're going to equate that to this morning, I'm not convinced that what you said about Dr. Corsi is correct. And so that's the issue that I take on that regard. But
you don't convince that it's correct in that it happened, or you think that it didn't happen?
I'm not sure that it's exactly happened as you described it to have happened. They talked about the chair and those things, and there was an explanation for that.
That he didn't know about it.
That's correct.
Right. I acknowledge he said he didn't know about it, which I think is a cause for grave concern. But the financial side of things is also a cause for grave concern. And I don't see how moving it to that same process is going to do anything about the financial malfeasance that happened with History Nebraska. I'm trying to understand, you want to have greater transparency and oversight, but from my vantage point from today, shifting it from where it is to a code agency is actually taking away more transparency, because the administration has worked very hard to limit transparency and limit our ability to provide oversight to state agencies. But we have that ability to provide oversight to History Nebraska now that we would no longer have as a state agency.
Well, I think that's exactly what we have with History Nebraska now. There's no transparency at all.
There is if
There's
we
none.
ask for it.
There is none.
No, we can ask.
And they've been doing this since 1994.
We can
And
ask
this is an
for
experiment that we've
transparency.
tried long enough. It's time to make a change.
We can ask for their records. We can ask for all the things, and they would give them to us. We can still ask for that stuff.
But they
So-
don't give it to you. And Senator Lemke testified that in the committee, that he had asked for the audit. He wanted to see the audit, and they never gave it to him. So don't say that if we ask for information, they're going to give it to us, because that's not been the case.
Well, did they give a reason for not giving it to him?
Yeah, they said it was private.
So that is an instance where, like, if somebody said that to me, I would go back to them, and I would eventually bring it to the executive board for legal action to be taken, because that is against our own laws. So the fact that they didn't do it doesn't mean that they don't have to do it. It just means that they didn't do it. And there's steps and processes that are very laborious, but they are there to go through. So I appreciate you answering my question, Senator Erdman. I'm just not convinced that this is going to lead to more transparency. And I think I'm about out of time. Thank you, Mr. President.
Senator Conrad, you are recognized.
Thank you, Mr. President. Good afternoon, colleagues. Just to echo some of the concerns that members have expressed thus far, simply by moving an agency classification from independent to code agency does not increase transparency. The same rules apply as to public records, public meetings. It also does not inoculate an agency from waste, fraud, and abuse. As we know, many of our most troubled state agencies are in fact code agencies. So that's again the principled reason why I don't understand the remedy sought in this particular measure. The other thing that I want to let you know, just from a technical perspective, are the lines that Senator Erdman quoted in regards to the initial legislation. They do not mirror my amendment, colleagues. They are about generalized duties regarding setting annual meetings, having membership classes, and then yes, there is a line that there would be adherence to museum and archival standards. However, they're not identical. That's very, very generalized, number one. So it's not redundant. But let's just take Senator Erdman's argument a bit farther. Even if it were redundant, it would not do any harm to adopt AM 2944, which of course my amendment is not redundant. And you need to compare AM 2944 with the lines that Senator Erdman lifted up. Additionally, what Senator Erdman, I think, perhaps conceded by trying to lift that out in the original legislation, that he's saying you don't need my amendment because we're already going to protect academic freedom and free expression. I hope that's the case, and I hope he reaffirms that commitment on the record, because the existing language in the legislation does not do that. That's why I have specific clarification and reaffirmation of that in the amendment before you. And then finally, what Senator Erdman conveniently leaves out is that the original legislation is essentially just a reshuffling of existing statutory duties and obligations for History Nebraska. However, colleagues, that reshuffling did not have specific protection for free expression and academic freedom because it was an independent agency, Senator. So there wasn't a need to have that specific protection in the language that you're quoting, which is a reshuffling of existing duties, because it was written and it worked when it was an independent agency. So for those reasons, I want to point out why Senator Erdman's opposition is circular and nonsensical in regards to opposing my measure. This does not disturb the remedy that he sees fit to bring forward, which I have a principled disagreement with. But the existing language, which was written at a time when the agency was independent, does not mirror my amendment. And it's more important than ever that we adopt it as we change the structure of this agency to ensure that there is not political interference with the work of History Nebraska, which should not be partisan, which should not be political, which should adhere to appropriate standards when it comes to how museums operate, how academic freedom interfaces with the operations and exhibits at History Nebraska. So this really is a very modest amendment. There's no reason to create, I think, a big opposition to it, unless the motives are something other. If the motives are to ensure political interference, then you should vote against it. And you should be honest about your motives and say that you want the governor utilizing a heavy hand to set the operations and the exhibits and the work of History Nebraska. Because if that's not your intent, they can still be a code agency and we can still have modest, reasonable guardrails that protect academic freedom in AM 2944. Thank you, Madam President.
Senator John Kavanaugh, you're recognized.
Thank you, Mr. President. Well, I appreciate everything Senator Conrad was saying, and that we should really ensure that anything we do does protect the freedom to present an accurate history of our state and our country. And I really do appreciate the concerns raised by Senator Brewer and Senator Erdman. I think if they're mishandling historical artifacts, that is a big problem. We had a bill in General Affairs this year brought by Senator Aguilar that was about helping museums find homes for items that are not appropriate for them. It was a really interesting hearing. We had a lot of folks come from smaller museums across the state, and they talked to us about the challenges associated with getting items that don't quite fit their collection, but they have a moral and ethical obligation under their commitment as historians to continue to preserve these things in the appropriate fashion. And then that's becoming prohibitive, but they had this other burden of how they can, send these places to other places that maybe would be in a more appropriate home. So Senator Aguilar's bill addresses that helps them to move these things to a more appropriate home. I think it actually might be on the agenda or was on the agenda today on Select File. But folks who go into this field obviously are lovers of history and have no interest in damaging historical record, but they do want to present an accurate record. And there are obviously folks who disagree with an accurate portrayal of history. Some people find our history to be, sometimes being truthful about our history, people would find to be disfavored, right? And so people push to quiet those true stories. And so Senator Conrad correctly pointed out, if we're not worried about that, if we're worried about the other parts, we're worried about the impropriety and money spending and inappropriate destruction of items or loss of items or disposition of items, if we're worried about the lack of engagement from the board, there's different solutions. And if we're worried about those things, then Senator Conrad's amendment is not a problem for this bill. It does not undermine the intention of this bill, because it just asserts our commitment to protecting that accurate representation of history and not politicizing it, not injecting the governor into it. So like I said before, I support AM 2944, and I had opposed 1169 before, but I do think AM 2944 improves the situation. I would, again, I think I'm going to run out of time here, so I might push my light and talk again, but I do think there are fundamental issues of lack of oversight across the board in this state. I think what happened this morning is a microcosm of this. I have stood up and opposed appointments, and to Senator Erdman's credit, he and I opposed appointments together, and we both had problems with someone. And engaging that sort of oversight and making sure that people know that the legislature is paying attention, that you can't be a bad actor and just get away with it. That is one of our functions. Asking people questions at those hearings, not reappointing people who have been bad actors. We need to take a more, thank you, Mr. President. We need to take a more affirmative approach on these appointments to ensure that this sort of asleep at the switch sort of boards doesn't happen. A more reasonable or more intermediate step might be to reconfigure the board. Senator Erdman said 3 appointed by the governor, 9 appointed by the membership. Maybe that, makeup is leading to the problem, but turning it into a code agency, making it entirely at the discretion of the governor, taking away the authority or input of the board, which is, I'm sure membership of History Nebraska. I'm not even a member of History Nebraska, sad to say, but sure, those are people who are really invested in the success of this organization, and they are upset about this conversation we're having, that it became necessary to have this conversation. So I think that there's probably an intermediate step, but like a lot of things, we are where we are right now.
Time, Senator.
Thank you, Mr. President.
Senator Michaela Cavanaugh, you're recognized to speak.
Thank you, Mr. President. Sorry, I was standing off to the side. I tried to not be on camera, and I got caught over there when Senator John Kavanaugh started talking, and then I realized that I was next. So, and we, for those at home, do not sit next to each other. We are on opposite sides of the room. So, okay, so I am always a little nervous when we have legislation that is in reaction to a specific situation, although I think sometimes that is very much warranted. But there was financial malfeasance with the director of History Nebraska, and it was found, and it is going through the courts. That's good. It's a problem that it happened to begin with, but it's good that it's been found and it's going through the courts. It's an $8 million budget, is what Senator Erdman stated, and if we did this, we'd be moving it under a state agency, and presumably it would enjoy the same level of scrutiny that our other code agencies have, including the director process, which is not transparent at all. So the way a director is selected for a state agency is that the governor appoints said director. That's the beginning, middle, and end of the process. That is the process in its entirety. The governor does not have to vet this person. The governor does not have to released a list of names of people that they interviewed. They do not have to post the position anywhere publicly. They just get to name the person. And then that person comes in front of us and we presumably ask them questions about their work history and their ability to do the job. And then we vote it out of committee, and then it comes to the floor and we vote it forward, and then they are confirmed. That is the process. And as we saw today, we spent less than 2 hours on that process. Less than 2 hours for a head of an agency that is $1.6 billion. And we want to move an $8 million agency under the administration so that they can enjoy the same level of rubber stamp oversight. I just find that to be a hard argument for me to accept. I was initially on the fence about this bill, but the notion that we will do nothing to put in any sort of guardrails whatsoever around gubernatorial appointments and then add to who those appointees are, that is very problematic to me. This person is at least appointed by a body that is semi-elected by its own membership. Whether they did a good job on the most recent appointee or not isn't what we should be focusing on. We need government oversight. And
1 minute.
I'm just gonna preview another concern I have, since I only have 1 minute left. Another concern I have of moving an agency that has a pot of money under the administration is, wait for it, they're gonna sweep the funds and eliminate the agency. Because, I mean, that was an entire bill this year, was sweeping cash funds and eliminating programs and committees to do just that very thing. So that's clearly the intention of the administration. And I don't believe that that's necessarily Senator Erdman's intention, but I think that that is an intention of the administration. So I think I'm about out of time, and I will get back in the queue. Thank you, Madam President.
Thank you, Senator Michaela Cavanaugh. Senator Conrad, you're recognized.
Thank you, Madam President. I was hoping that Senator Erdman might yield to some questions.
Senator Erdman, will you yield?
Yes.
Thank you, Senator. And I know you've looked at this issue from every possible angle, and that's why you brought the bill forward, and that's why you made it your personal priority bill. And again, this amendment would not change the remedy that you seek, and I think the bill is on its way to the governor's desk this session. But there was a clear undercurrent at the hearing and in subsequent communications I've received from concerned stakeholders with History Nebraska that additionally prompted me to bring this specific protection for academic freedom and free expression in regards to the operations of History Nebraska. So let me I know you're a candid person, I am as well. Do you believe that the governor should involve himself in decisions like whether or not History Nebraska has an exhibit on redlining, which lifts up systemic racism?
Are you asking, should the governor have an opinion on that?
Yes.
You mean have oversight on that or have an opinion? I'm sure he has an opinion on it.
Sure. Exercise his authority as governor in terms of his relationship to the agency. The governor sets the policy for HHS, corrections, and other code agencies. Should the governor be able to veto an exhibit on redlining, which lifts up systemic racism?
I don't think he will. I don't think he does.
Okay, I'm not asking if you think he will, or I'm asking, do you think he should have that ability?
No.
Okay, Senator, I agree, and that's why I have this amendment in here.
I was trying to figure out what you were trying
to protect the ability of the agency to move beyond political interference. And again, it's not an indictment of Governor Pillen. We don't know who's going to be in that office in the future. It's ensuring that there's not political interference. Senator Erdman, do you believe the governor should be able to tell History Nebraska if this bill moves forward that they can't go to a gay pride celebration?
No.
Okay. That's exactly why I have this protective language in here to protect academic freedom and free expression for the agency, because in a code agency, the governor literally gets to direct the director in terms of policy decisions for the agency. So if you agree that the governor should not be making political decisions as to the operations or exhibits that the agency is involved in, I would ask you, in aligned with the Q&A that we just worked through, to please reconsider supporting AM 2944. It's not meant to be a sneak attack. That's why I brought it to you days before I filed it. It's in line with how the Nebraska Arts Council works. And I think actually our goals in regards to protecting academic and free expression from political interference from that last Q&A are 100% aligned. So you're not losing anything by adopting this amendment. And I think it would alleviate some of the fears and concerns as your bill moves forward that a lot of people have brought forward to me as a committee member on government. So I appreciate your yielding to questions, and I'll leave it there. Thank you, Madam President.
Thank you, Senator Conrad. Senator Kavanaugh, John Kavanaugh, you're recognized, and this is your third opportunity.
Thank you, Madam President. Well, I appreciate the conversation between Senator Erdman and Senator Conrad was illuminating. And again, I would say I support AM 2944 for the very reasons that Senator Conrad articulated in that conversation, which is that if we have a problem at History Nebraska, it might be more in the administration and not in the projects and things they choose to lift up. And so we should enshrine the protection in the decision-making about which projects to lift up. I would say my first year here, there was a great exhibit about redlining at the History Nebraska Museum that referenced the book Evicted by Matthew Desmond, and had a whole big, I actually invited everybody here. I didn't know a lot of you at that point because it was so early, but ended up going by myself, not hurt that people didn't take me up on my invitation. But just so you all know, you all were invited to join me for a tour of History Nebraska to see the redlining exhibit about how evictions disproportionately affect women, and particularly women of color, and all of the societal ills. And you might notice that I do talk a lot about those sorts of things when I'm talking about evictions and talking about criminal justice issues, because there's parallel and equating to a lot of the problems that we see in our systemic problems as a result of people becoming homeless in a quick fashion, and how that bleeds into the criminal justice system and the social safety net and all the costs associated with that. And that a lot of those things I talk about come from both reading that book by Mr. Desmond, but also going to that museum. And so, these things have value. These art exhibits, historical exhibits have value. They find their way into the conversation and to the policy that I have brought forward. And so I really appreciate those choices, and which is why I'm interested in this topic. But I also, to tie the two things together, see the value of what Senator Erdman's saying is problematic boards. And, like I've said, a lot of appointees here. I have the committee chairs and the committees I sit in can tell you that I ask a lot of questions, and I ask a lot of questions of board members. And I, a lot of times, am not, I'm candid with them, I would say, and let them make sure that I give them the hard questions, give them softball questions too. But I think it's really important that we let people know at the minimum that we're watching, and that you don't get a free pass on these boards. And I do think there's room for more oversight. And in that vein, to tie the things together, Senator McKinney and I have been working on a bill that we advanced last week that does just that by looks to add more oversight to one particular board, which is the Omaha Housing Authority Board. We didn't change where that board is. We changed some of the requirements for meetings. We changed some of the people who are on the board by requiring more input from parties that are affected by it. But we made that bill kind of make smaller changes to address the concerns that have been raised about that board. But I do think it is a good parallel to this bill and say, we recognize that there are problems and that we do need to do something. So that's why I do appreciate the work that Senator Erdman and Senator Brewer have done on this bill. And of course, but I support Senator Conrad's proposal to protect that, what is so precious about both, well, she said this came from Arts.
1 minute.
Thank you, Madam President. To protect intellectual independence, to protect honesty in presentation of history, and making sure that these things are not stifled artificially for political purposes. And Senator Erdman said he's not interested in such stifling. So to that point, AM 2944 should not undermine the intention of this bill, and so it's something that I think everyone should support. So I'd encourage your green vote on AM 2944. Thank you, Madam President.
Thank you, Senator Kavanaugh. Senator Kavanaugh, you're recognized, and this is your last time to speak.
Thank you, Madam President. I was actually going to ask Senator John Kavanaugh if he would yield to a question.
Other Senator Kavanaugh, would you yield to a question?
Oh, gosh. Yes, and I know what it is.
I'd like to give you the opportunity to correct the record of, did you in fact go to the redlining exhibit at History Nebraska by yourself? Or was your company so forgettable that you forget that you had company?
Well, so I went by myself and someone showed up late. And I thought I would spare the embarrassment of tardiness.
Oh, okay. Well, don't feel like it's necessary to spare the embarrassment of tardiness. We all know that we can run late from time to time in this job, getting to and fro on our very limited breaks. But I mean, I did go through the exhibit with you, so much so that I remember us going to the map and taking a picture. There is photographic evidence of the two of us at this exhibit in front of our father's childhood home on the map. Anything? Would you like to correct the record, sir?
Yes. Senator Kavanaugh did accompany me to History Nebraska. She did arrive a little late, but we were there together for some part of the time.
Okay, thank you, Senator John Kavanaugh. I mean, I couldn't let that stand. He did, in fact, issue an invitation to the full body, and I accepted that invitation. I don't remember what kept me delayed at that time. I'm sure I was in communication with him. I do recall walking back to the Capitol with him. It was very cold out, and if any of you have walked anywhere with Senator John Kavanaugh, you will appreciate that he walks very fast and is about 7 inches taller than me. And so he walks very, very fast, and I was freezing, so I was like running behind him. But I would hope that I was slightly more memorable than that. I mean, we did go through the entire exhibit together, even if I was late, as Senator John Kavanaugh states. I had other things to say, but I really got derailed by that one. I was fiercely wanting to defend my attendance at the History Nebraska redlining exhibit. So thank you, Madam President.
Thank you, Senators John and Michaela Kavanaugh. Seeing no one else in the queue, Senator Conrad, you're recognized to close on AM 2944.
Thank you, Madam President. Good evening, colleagues. I want to thank everybody who has participated in the debate on the mic and off the mic. I've had a chance to talk with my friend, Senator Erdman. I think debate was illuminating and showed that we were actually much closer together than we thought when we started the debate today. It's my understanding that Senator Erdman has reconsidered his position. He's willing to accept AM 2944 as a friendly amendment. And we feel that if this amendment is adopted by the body with Senator Erdman's agreement, that then my friend Senator Kavanaugh and Senator Dungin will be withdrawing the additional amendments that they have filed on this measure so that the measure can move forward without additional debate today. So that being said, look to Senator Erdman. Maybe he'll give you a thumbs up. Look to his vote on the board when the time is right. But the debate was illuminating, important, and helped us to show that we were actually closer together than we thought when we started. And even though I still think it's the wrong remedy, I do think that this makes the bill better and will provide a great deal of peace of mind to a lot of the stakeholders involved in this important work to ensure that their important work continues without political interference. Because Senator Erdman's exactly right. We got to get Nebraska history back on track because we have a lot of beautiful stories to tell. And we need to keep the focus on the mission, not on leadership failures and classification structures and things of that nature. Hopefully this will provide an opportunity for History Nebraska to reset with protections for academic freedom and free expression so that they can tell the good stories about our past and present at History Nebraska. I'd urge your favorable consideration of AM 2944. Thank you, Madam President.
Thank you, Senator Conrad. The question before the body is the adoption of Amendment 2944 to LB 1169. All those in favor vote aye. All those opposed vote nay. Have you all voted? Record, Mr. Clerk.
35 ayes, no nays on adoption of the amendment, Madam President.
The amendment is adopted. Is there anything further on the bill?
I have nothing further, Madam President.
Senator Ballard for a motion.
Madam President, I move that LB 1169 be advanced in our for engrossing.
There's been a request for a machine vote. Colleagues, all those in favor, please vote aye. All those opposed, please vote nay. Record, Mr. Clerk.
31 ayes, no nays on advancement of the bill, Madam President.
The bill is advanced. Next bill, Mr. Clerk. Excuse me, items for the record.
Thank you, Madam President. Your Committee on Enrollment and Review reports Legislative Bill 1188 to select file with ENR amendments. Additionally, amendments reprinted from Senator Linehan to LB 1402, new A bill 1306A for Senator Merman's bill for enacting new appropriations. Changes and eliminates appropriations to aid in the carrying out of the provisions of Legislative Bill 1306. Repeals the original section, outright repeals Section 16, and declares an emergency. Legislative Bill 1329A, introduced by Senator Merman. This bill for enacting new appropriations, appropriate funds to aid in the carrying out of the provisions of Legislative Bill 1329, change appropriations, repeals the original section. Legislative Bill 1416, introduced by Senator Bostar. This bill for enacting relating to appropriations, appropriate funds to aid in the carrying out of the provisions of Legislative Bill 1416. Legislative Bill 1300A, introduced by Senator Boestar, it's bill for enacting appropriations to appropriate funds to aid in the care and the provision. Legislative Bill 1300, and to declare an emergency. Legislative Bill 233A, introduced by Senator John Kavanaugh, it's bill for enacting appropriations to appropriate funds to aid in the care and the provision. Legislative Bill 233. Legislative Bill 937A, introduced by Senator Boestar, it's bill for enacting appropriations to appropriate funds to aid in the care and the provision. Legislative Bill 937. Legislative Bill 1074A, introduced by Senator Slama, it's bill for enacting appropriations to appropriate funds to aid in the care and the provision. Legislative Bill 1074, and declare an emergency. Legislative Bill 1073A, introduced by Senator Slama, it's bill for enacting appropriations to appropriate funds to aid in the care and the provision. Legislative Bill 1073, and to declare an emergency. New LR 378 from Senator Merman, that'll be referred to the Executive Board. LR 379 from Senator Boestar, also referred to the Executive Board. LR 380 from Senator DeBoer, and LR 381 from Senator DeBoer, both referred to the Executive Board. Senator McDonald 382 referred to the Executive Board. LR 383 from Senator Hughes referred to the Executive Board. LR 384 Senator Linehan referred to the Executive Board. LR 385, introduced by Senator Linehan, referred to the Executive Board. LR 386, introduced by Senator Day, referred to the Executive Board, as well as LR 387. LR 388, introduced by Senator Wishart, that'll be referred to the Executive Board. LR 389 from Senator Clements. LR 390 from Senator Brewer, and LR 391 from Senator Von Giller, and all referred to the Executive Board. That's all I have this time, Madam President.
Thank you, Mr. Clerk. Next item on the agenda.
Madam President, select file Legislative Bill 1288. First of all, Senator, there are E and R amendments.
Senator Ballard for motion.
Madam President, I move the E&R amendments to LB 1288 be adopted.
Colleagues, you've heard the motion. All those in favor say aye. All those opposed say nay. The amendments are adopted.
Madam President, Senator Albright would move to bracket the bill until April 18, 2024.
Senator Albright, you are recognized to open on your motion.
Well, thank you. I appreciate this time. Thank you, Madam President. Colleagues, the reason I've asked for this motion is to try to help to educate some of you on what goes on in Thurston County. And while I live 7 miles away from the Winnebago like town, where our children have gone there for preschool, we have gone to the powwows. We absolutely are engaged with the tribe as well. And I have been tribal chair for probably 6 of the 8 years that I've been here. What I want to tell all of you first is I know that anybody that would like a bill to come before us, the tribes would get one bill to choose from. I have not yet been in a meeting when it comes to which bill we're going to select for the tribes this year. I know I've heard of the water issue, which we already addressed last week. I've heard about the regalia, which was already taken care of. So that's 2 bills. And now we have this third one. And I know that Macy is concerned about, the Omaha Natives are concerned about the women, being taken off the reservation. But knowing that we get 1 bill and now we're on the third one is a concern of mine. No matter what committees, special committees they have, you're to be able to select one. But putting that aside, I want to talk to you for the next 10 minutes about what happens with Thurston County government and versus, and not versus, but in addition to the tribe when they have to work things out. So subjects that are domiciled on Indian and under Indian country, the United States Constitution under United States Constitution 1151 legally includes all people residing on the historic Indian reservations. That would be our family, as well as them. Page 5, lines 26 through 27 states that, quote, such documentation shall clearly identify the subject, identify the relevant tribe, and allege the officer's belief. This statement does not identify the subject as a tribal member. Federal Indian law is complicated. Oddly, senators sponsoring this bill do not have Indian country in their districts. The stakeholders and legal experts should have included county judges, county attorneys, county law enforcement, and the state law enforcement who regularly deal with legal issues in Indian country. The bill passed through committee 8-0 because the state stakeholders and the legal experts within the Indian county were not consulted or even made aware of this bill, including myself. Nebraska is a mandatory public law 280 state, where the state was granted civil and criminal jurisdiction over tribal members. The Nebraska Legislature and the Department of Interior returned that jurisdiction to the federal government for the Thurston County tribes in 1969 and 1985 to save state resources. Changing two large bodies of state law to include a separate sovereign desires makes no fiscal, legal, or logical sense. The federal government has a trust and a fiduciary responsibility for the tribes, not the state. Indian Health Services, which I will be referring to IHS, has mechanisms for healthcare needs, including mental health for Indian tribes. The tribe's sole focus is to get patients the care they need in times of crisis, which is the same issue states entities have. Counties, too, are faced with holding sick individuals in jail or releasing them to the public due to a shortage of available state beds. It is not necessary to rewrite state law. The federal government should address the tribal's sole focus through the IHS, or the Indian Health Services. But this bill, I believe, is truly premature in passing because there's no consultation with our local law enforcement, nor was there any notice to the citizens most impacted by this bill. The county impacted most by the implementation of this bill will be Thurston County, located in District 7. I live in Thurston County, which is wholly considered Indian country. The bill was introduced by Senators Rabel, District 28, Senator Conrad, District 46 in Lincoln, and Senator Day, District 49 in Omaha, with no Indian country in their districts. This bill proposes drastic changes to two large bodies of law, the Nebraska Mental Health Commitment Act and the Sex Offender Commitment Act. It changes the process currently followed by all county and state enforcement authorities and unconstitutionally subjects non-tribal Nebraska citizens to tribal law and tribal court where they live and have no vote or no voice. The Thurston County Sheriff and the Thurston County Attorney's Office were unaware of this bill until February 22nd of 2024. The local Nebraska State Patrol captain was emailed a general question back in January of 2024 about service warrants in tribal lands, but there was no reference specifically to the details outlined in LB 1288. This bill is premature for passage because Indian reservation jurisdiction involves complex legal issues. Any legislative bill intending to alter that jurisdiction deserves discussion for clear understanding of the legal effect, careful consideration of constitutional rights of all parties involved, and most certainly consultation with your state government officials mostly impacted by this passage. So on January 17th of 2024, this was referred to the Judiciary Committee. January 25th of 2024, the notice of hearing for February 1st was posted. February 13th, 2024, State Tribal Relations Priority Bill. February 20th, placed on general file. February 23rd, 2024, Senator Rabel amended and filed. This bill expands the tribal jurisdiction over non-tribal members in violation of a federal law. The language subjects domiciled within Indian country legally encompasses all citizens of Thurston County, whether they are members of an Indian tribe or not. This bill provides that all subjects domiciled within Indian country, as identified by 18 United States Constitution 1151, page 2, line 23, are placed under the jurisdiction of tribal court and tribal law for the mental health and the sex offender proceedings, rather than the state process followed in all counties for state citizens who are not members of a federally recognized Indian tribe. And then subjects for the mental health is 71-912, and it applied to this bill. Subject means any person concerning whom a certificate of petition has been filed under the Nebraska Mental Health Commitment Act. Subject does not include any person under 18 years of age unless such person is emancipated minor. Domiciled is a legal definition in the Black Law Dictionary. The place at which a person has been physically present and that the person regards as home, a person's true fixed principal and permanent home to which that person intends to return and remain. So Indian country is 18 U.S.C. 1151. All land within the limits of any Indian reservation under the jurisdiction of the United States government, notwithstanding the issuance of any patent, and including rights of way running through the reservation. All Indian allotments and Indian titles to which have not been extinguished,
1 minute,
including rights, thank you, rights of way running through the same. As written, this bill does not distinguish tribal members from tribal citizens domiciled within the historical boundaries of the Indian reservation. All Thurston County is considered Indian country, as 18 U.S.C. uses its historical 1800 boundaries from the Indian treaties. Subject acts of Congress encourage non-tribal people to purchase original reservation surplus and allotted lands over 100 years ago. Many of these non-tribal people were immigrants solicited by the government to settle in Thurston County and become farmers. Over 60% of the land in Thurston County is owned in fee patent by Nebraska citizens, many of whom are third and fourth generation farmers. They are not members or affiliated with the Indian tribe. They do not receive tribal benefits, and they and their ancestors have paid state taxes on this property since owning the land in fee patent. Using the term subject.
Time, Senator.
Thank you.
Thank you, Senator Albright. Senator Raybold, you're recognized.
Thank you, Madam President. Good evening, colleagues. I can tell that it is clearly Senator Albright's attempt and wish to kill this bill, which is her right to do so, but I cannot stress enough how extreme that option is for a bill that only allows for the recognition of orders to hold, commit, or place an individual in emergency protective custody. I want to give you a little bit more of the history of this bill. It was presented before the Judiciary Committee, and it passed out of Judiciary Committee 8-0. During the hearing, no one spoke in opposition to this. I'd like to ask Senator Day a few questions, if I may.
Senator Day, will you yield?
Yes. Senator Day, could you tell us a little bit about the process? After it was execed out of Judiciary Committee, it was taken up by the Tribal Relations Committee. Could you tell us the process that you went through, the meetings that were held, and who was in attendance, and how the decision came about?
Yeah.
To make it your priority bill.
Yes, so I'm the chair of the committee, and because it's a special committee, we do not take an official vote to make a decision on a priority. We did have 2 executive sessions, both of which Senator Albright was invited to and she was made aware of. She did not show up to either one of them. We collectively made the decision to make LB 1288 our priority bill in discussion with the rest of the committee, and it was agreed upon by everyone that attended the meetings in which we made that decision. I even went up to Senator Albright after we made the decision to make it our committee priority and I made sure to tell her about it, to let her know this is the decision that was made. And she said at that time that she had planned to support the bill. So it's an unfair framing of the discussion to say that she was not aware of the meetings or discussions that we had within the State Tribal Relations Committee to make this our committee priority bill. She chose not to show up to the executive sessions.
Thank you, Senator Day. I want to just even give you additional references. The bill inception came about after Senator DeKay and Senator Day and myself visited with the Omaha tribe in Macy's. We had a beautiful day spent with the tribal leaders. After lunch with them, we sat down and asked, okay, what are your concerns? What are your issues? And we thought it would be dealing with methamphetamine or other matters that are critically impacting their community. And they said their number one priority bill over and over and over again, their priority concern was that their tribal judges' EPC orders are not recognized for those that are experiencing a mental health crisis. And oftentimes their tribal members are detained in a jail, or they're forced to be transported to another facility 200 or so miles away to get the treatment they need. And so that was the inception of the bill. I worked last summer with the Nebraska Supreme Court thinking that they might be able to come up with an administrative solution, because all the other orders issued by a tribal judge are recognized throughout our entire state of Nebraska. And their orders are also respected throughout the entire United States. So it was truly a quandary why these EPC orders were not recognized. And so that became their major concern. So we went forward.
1 minute.
Thank you, Madam President. We went forward with that concern, worked with the Nebraska Supreme Court. They had meetings involving tribal leaders as well as the justices to try to come up with a solution. Ultimately, they returned back to me that it's going to be a legislative solution to help resolve this, and we support that and wish you luck. And so I wanted to say also that this is not something that just impacts the communities that have tribal reservations on it. You may think it doesn't impact your community because Indian Territory only exists in a few of the districts of our colleagues. That could not be further from the truth. My heart really goes out to any person in a mental health crisis. Someone experiencing suicidal ideation is in need and deserving of our help. Every Nebraska family wants that for their loved one. And when I get back on the mic, I'd like to dispel some of the misinformation from Senator Albrecht.
Thank you, Senator Raybold. Senator Michaela Cavanaugh, you're recognized.
Thank you. I yield my time to Senator Raybold.
Senator Raybold, you're yielded 4 minutes, 57 seconds.
Thank you, Senator Cavanaugh. You know, we passed out an LB 1288 fact sheet on the very first time this was presented on general file. I want to be very clear about what this bill contains and what it does not contain. This bill only impacts tribal members living on tribal lands. That's on page 5, line 26 and 27 of the green copy of the bill. It states the relevant tribe to be documented. Next, the bill does not allow a tribal court to place a non-tribal member domiciled in Indian country under an emergency protective order or hold order. I want to say that again in case anybody didn't understand as clearly as I said it the first time. The bill does not allow a tribal court to place a non-tribal member domiciled in Indian country under an emergency protective order or hold order under the Mental Health Commitment Act or Sex Offender Commitment Act, regardless of whether they are domiciled in Indian country or not. Next, there is no expansion of a tribe's jurisdiction in LB 1288. that they do not have that then the state of Nebraska does not have that statutory authority. It only comes from the federal government, and there's no language in this bill that even remotely comes close to deliberating that. Tribal jurisdiction is inherent, but restricted by federal law. A state cannot expand tribal jurisdiction. Again, the language subject domiciled within Indian country is used to distinguish from tribal members who are not domiciled with Indian country. So for a tribal member not domiciled in Indian country, say someone in Lincoln, Nebraska, an EPC or mental health commitment would be handled under our state law, just like every other individual in our state of Nebraska. Next, the tribe is responsible for the costs of treatment and services and transportation. In LB 1288, I marked up the sections that clearly talk about where the tribe is responsible for the payment of the EPC, the transportation costs, as well as the treatment. It's in the bill 7 times, and it's on page 4, page 9, page 11, page 19, page 21, 22, and 26. So the tribe is responsible for the costs of treatment and services and transportation. For non-tribal members, the state is already set up and works regardless of where they live in the state. The gap is regarding tribal members domiciled on reservations. Arrangement for the payment of treatment services or conveyances for tribal members under LB 1288 will be established under a memorandum of understanding. This is similar to memorandums of understanding utilized by tribes and law enforcement regarding traffic patrol on state highways that run through tribal land. The tribe's sole focus has been to get patients the care they need in times of crisis. Thank you, Madam President.
Thank you, Senator Michaela Cavanaugh and Senator Raybold. Senator Duncan, you're recognized.
Thank you, Madam President, and good evening, almost colleagues. I do stand today opposed to the bracket motion and in favor of LB 1288. I just want to take a couple of moments to, I guess, further clarify or discuss what is and what isn't in the bill. First of all, Senator Raybold's been an absolute champion for this bill since the beginning, and I want to laud her and Senator Day and the others who have pushed this forward. In addition to that, I want to also, I guess, point out the fact that I think that Senator Raybold's done a great job already of articulating what is and what isn't in this bill. When this bill first came before the body the last time this was around on debate, there was a lot of discussions around the concern that this expanded the ability of the tribal courts to have jurisdiction over people they don't already. I will echo Senator Raybold's sentiment that my reading of this bill multiple times and discussing it with experts in this field is this does not do that. 1288 does not in any way, shape, or form change who the tribal courts have jurisdiction over. The reason for that, which has been, I think, talked about already a little bit, is that is who they have jurisdiction over is an issue that we don't necessarily have authority over. The U.S. Supreme Court has outlined very specific criteria as to when a tribal court does have jurisdiction over somebody in a civil matter, which is what this ultimately is. It's a civil matter. And I'm not going to bore people paying attention or listening at home with going through the entirety of those cases, but rest assured there is a very specific and set out process for determining when jurisdiction does or does not exist. This bill doesn't have any actual change or modification of that. What this bill seeks to do is simply to make sure that if an emergency protective custody order, an EPC order, has been issued by the tribal court, that it is also honored by the state of Nebraska in those other facilities in the event that the individual who's been subject of that EPC needs to be transported somewhere else by virtue of not having a facility nearby or by virtue of maybe those facilities being full. And so this is addressing an issue in our law where right now, if somebody has a valid EPC issued against them by the tribal court and they are being taken for that emergency protective custody over to a state or another facility outside of the tribal lands, they can be turned away. And that's a really, really big problem for both the individuals who need that emergency protective custody and also our community as a whole. The point of these EPC orders, for those who don't know at home, is it's essentially an order that is enacted if such person is deemed to be essentially harm to themselves or others, right? So if somebody's having a very severe mental health crisis and it doesn't rise to the level that they've broken any laws and they haven't committed any crimes, and so they don't need to be taken to jail, because certainly jail's not the right place for somebody suffering from a mental health crisis, but out of an abundance of concern and care for either themselves or the protection of others, the determination is made by the courts that that person needs to be taken somewhere. So the EPC is trying to keep both that individual as well as other members of the community safe from somebody who is suffering through an episode or an issue. And so what this simply does, 1288, it really is more of a cleanup than anything else. It seeks to say, if a tribal court has issued such an order, as we do with other things ordered by tribal courts, such as civil judgments, child support, any number of other things that are recognized, the state of Nebraska then must also recognize that emergency protective custody order, the EPC, the same way they do everything else. This harmonizes the current statute with the way that things work in other circumstances. A good example of this is, I believe under federal law, if you receive a protection order in like a domestic violence case from a tribal court, that protection order, thank you, Madam President, that protection order is recognized by the state courts as well, or outside of the tribal land. We are simply trying to harmonize the EPC statutes in order to ensure that it's also being recognized the same way. So colleagues, rest assured, I understand the concerns that are being raised. We certainly don't want to modify massive swaths of law with regard to what jurisdiction is and isn't for certain courts. This does not do that. 1288 simply says that we as the state of Nebraska will recognize those orders from the tribal courts. So I don't have any concerns about the expanded jurisdiction. I do think that there's been a lot of effort and work put into this from experts in the field, from individuals who certainly know more about it than I do with regards to what it does and doesn't do. And so I'm confident, colleagues, that if we adopt 1288, we're simply solving a problem that currently exists. And I don't have concerns that we're creating other ones. So with that, I'd encourage your green vote on LB 1288, and I'm opposed to the bracket motion. Thank you, Madam President.
Thank you, Senator Duncan. Senator Erdman, you're recognized.
Thank you, Madam President. Good evening. So as I'm listening to the debate, and I tried to figure out what this bill did the last time that we had it up for discussion. So I was wondering if Senator Albright would yield to a question.
Senator Albright, will you yield?
Yes.
Senator Albright, I was reading over the transcript, and I began to look at the testimony. And one of the testifiers said the authority rightfully belongs to the tribes under the inherent sovereignty of the federal government and under its trust. So legal responsibility to provide health care to Indians, LB 1288 does not, and it is made clear by the Eighth Circuit that the state cannot be granted to state authority and other tribal law that the tribal members in crisis are protected through the federal trust responsibility to the tribe. So is this what your issue is with the bill, is the fact that we as a state don't have authority over the tribes? Is that what you're trying to tell us?
They are their own sovereign nation, and the federal government is the one that has the trust and responsibilities. As I've said earlier, that they have a beautiful hospital. I mean, I'm not going to stand up here and boo-hoo the whole bill, but I'm telling you, there is a beautiful facility that it would be a whole lot easier if we would open that up to have doctors and mental health professionals come into the facility than to have to transport.
Okay.
Because we don't even have enough facilities for that, but that was built by the federal government for the tribes.
Okay, so then the issue is we can't get people to that hospital. Is that the issue?
Well, they say that they don't hold them there because they don't have the mental capacity to help the mental health patients there. When it comes to the sex offenders, that's a completely different story.
So how does 1288 solve the issue that you're talking about?
I believe they would like to have somebody be able to transport them off the reservation to Omaha or Western Nebraska, Central Nebraska, wherever they would find help. but we in our county do not have the resources, even though they say they will pay for it. We don't even have the personnel to be able to do so. So,
Okay, so 1288 is not the answer because of the description you just gave me?
yes.
So what would be the answer in your opinion? How would we solve this?
Again, I really believe that they should utilize the facility they have. I think they should engage with the federal government, their federal delegation, and figure out a way to make that facility that they currently have, that both Omaha and the Winnebago can go to. So could Santee. Santee right now goes up to South Dakota with
Okay.
their folks. So they're not truly a part of this conversation. It's truly the Winnebago and the Omaha Nation that would be asking for these services.
Yeah, I appreciate that. That gives me some clarity there. I appreciate that. Thank you for answering my questions. Thank you.
Thank you, Senator Albright and Senator Erdman. Senator Sanders, you're recognized. Senator Sanders?
Thank you, Madam President. I yield my time to Senator Albright.
Senator Albright, you're yielded 4 minutes, 44 seconds.
Thank you, Madam President. Thank you, Senator Sanders. I do want to continue to talk a little bit more about some of the comments, because I can go into all of the laws, but I'm not an attorney. I'm simply reading from the passages that I have and the information I have in my office. So, but again, I know that they've been working with DHHS. Senator Abel has been in discussions with DHHS and the tribe. For 2 years, the stakeholders impacted most were not consulted. And Thurston County is the only county that is entirely Indian country. And we are also the poorest county in the state. There are reasons that that is the way it is. Senator Dungan does nothing to expand the jurisdiction set by the federal law. It must be done by the tribe. Funding worked out between the tribe and other groups. Federal governments pay the bill, already have established mechanisms to put into place to pay hospitals by the federal government. And I will just give you a quick example. Our Emerson Hubbard Fire District just went into a memorandum of understanding with the tribe to back them up if something should happen that they are not able to be able to fulfill the obligation to get to the fire or to an accident or whatever. And it's great when you can work those out and it works. But we have not been approached, and that is the big issue here. But more importantly, I know the state of Nebraska does a lot for the tribes when it comes to mental health. And there are a lot of programs that they have. There's a lot that they're doing right now. But when you ask to take them off of the tribal grounds and escort them wherever they want to go, even in the fiscal note, I mean, it talks about paying people, but it talks about having $29,460 at the Lincoln Regional Center, or $45,987 for a community-based hospital for these EPC services for one individual. That does not talk about transportation, getting them to and from, and where are you going to put them in the meantime if you can't put them in their local hospital, and or if they're a sex offender and they've been charged, you can't put them in jail. They want you to take them directly to one of these facilities. But again, it's about being able to communicate with one another, work together as we need to make these things happen. But tribal law is complicated. Yes, tribes are sovereign. And yes, they have their own courts. And yes, we need to recognize the legitimacy of the tribal courts. Why? Because the federal government has trust and fiduciary responsibilities for tribes, not the state of Nebraska. The State Tribal Committee and the Omaha Tribe met last fall. This was one of the #1 issues that they brought up. Their own court and judges issue EPC troubles with transportation. We even have trouble with transportation in our own county. In our neighboring county, Dakota County, they've called me. They have trouble. I mean, but it takes a law enforcement agency to put someone who is sworn in as an officer to take these people to these facilities. And Senator Brewer gave an example even of his brother taking, I think it was a child though, under 18, down to Omaha, just to find out that they didn't have any room for that child.
1 minute.
So then they have to bring him right back. So again, troubles with transportation, no authority to transport, and it's not recognized, or the hospital doesn't recognize the EPC. The hospital's responsible, the tribal hospital's responsible for tribal health care issues. It truly is a beautiful hospital in Winnebago, and it's only open to tribal members, and the funding is to come from the federal government. So the testimony from the Winnebago hospital employee, 72 suicide, they had 72 suicide cases, and in the hospital, they had 62 that had to be transported to other facilities. So I'm not sure what they're doing right now, but if they have their own tribal police and they also have the BIA, those would be two options for them to take. But I believe that this is more of a policy issue for our
Time,
state.
Senator.
Thank you.
You are also next in the queue, Senator Albright.
Okay, perfect. So again, I feel like that this is more of a policy issue than it is something to be recognized in state law, because we cannot ask for a facility to take them just because, if they have the ability and they have a bed. We have a huge problem in our state in general being able to take people with mental issues to a facility anywhere. And then when you load transportation on top of it, it's one thing if you're in Sarpy County and you have 200 deputies, but it's certainly a different story if you're in Thurston County with 4 to 6. We just don't have the capacity to be taking people from one spot to another. And I have to stand here and defend my county and our officers in our sheriff's department, because they are the ones that have to say yes to this and to agree to it. So I don't believe that even the money should be involved in our state statutes, that they would pledge this much money, because it could be more, it could be less. We don't need to be an agent of how they're going to take care of those things. Let's see. I think it was, let's see, there's a state. Okay, so I think Senator Botzen had problems with the bill with payments and the EPCs without more of an agreement with someone, or the discharges under the wording of the bill when it says treatment facilities may discharge, but tribe may disagree with the treatment. And then the firearms, the logistics of that. There's nothing keeping the hospital in Winnebago from contracting with the state facilities on behalf of the tribes. Changing state law is an extreme measure, for the stated goal of LB 1288. Again, Senator Dungan responded to some questions. Funding doesn't need a process or a procedure to receive payments, as agreements are already in place. And that's false from a county that is entirely Indian country. And the discharge authority on page 16, line 17 through 23, only requires the administration at treatment facilities to talk to the tribe before discharging the patient, and it doesn't give tribal authority to say no. And that is false. Discharge is authorized only with the consent of the tribal hospital, and consent equals permission to do so. The federal law about guns, we shouldn't have to put a law in. The federal law has to be followed. And we can't kick issues down the road, as it is an immediate problem. Placement is an issue for all counties too. Again, it's the problem for the federal government, not for our state. I believe, so the state, let's just say that the state of Iowa was having issues placing their mentally ill patients in a facility. Would the state of Nebraska change its state law to create a process for the Iowa citizens to utilize Nebraska facilities when Iowa would already have their own budget to address the issue? This bill, I don't believe is necessary. I think it should be a memorandum of understanding between whoever they want to do business with, and the state of Nebraska should not be a part of it. Thank you, Mr. President.
Thank you, Senator Albright. Senator Raybold, you're recognized.
Thank you, Madam President. I stand against this bracket motion, and I encourage everyone to vote against this bracket motion. If there is any doubt in anyone's mind, we have an amendment to add. It's AM 3106 that again reiterates and tightens up any further misgivings that specify that only a member of a tribe or eligible membership in a tribe qualify. For civil matters, tribes only have jurisdiction over non-tribal members if the individual consents. I also want to say that, you know, the tribal members don't have to go to Thurston County. In fact, some of them don't. They go over to South Dakota to get the immediate care and treatment that they need. Guess what? The state of South Dakota recognizes the tribal judges EPC from our state of Nebraska. And also, they're happy to accept payment from the Santee Sioux for the services that they have done an MOU and agreed upon. Senator Albrecht also mentioned the Winnebago tribe. They don't have the capacity in their wonderful new hospital because they haven't opened up a psychiatric ward or the appropriate care ward to do that. Because guess what? We're having a behavioral and mental health labor shortage in our state of Nebraska, in other states as well. It's extremely difficult to recruit. We've passed bills to make it easier to recruit and retain those licensed mental health therapists. It is a challenge. It's very difficult. Madam President, I would like to yield the rest of my time to Senator Brewer.
Senator Brewer, you are recognized for 3 minutes and 5 seconds.
Thank you, Madam President. Well, I got to tell you, I am not happy about being in the middle of this fight here. I think there's a issue that needs addressed that we're trying to do in 1288. So to bracket it does not address the issue. I just got off the phone with my brother and I said, you know, what's your feelings on this? And he goes, you can't put them in an island. You can't say that this place is unique and that we're going to sort certain human beings from other human beings because of a rule that will somehow prevent you from taking care of them. If there's a mental health issue, we got to figure out how to get them care. Now, does the sheriff always get reimbursed? He said no. He said there's times they transport and they don't. But he said you can't put them in a position where they're treated different, where they're not going to be taken care of because of someone not wanting them to go in a particular direction or because it's inconvenient to have certain people transport them. He goes, if this 1288 is something that's worthwhile, then what it needs to do is figure out how do you get them help. Now, it's a great idea to say you're going to put a mental health wing in a hospital, but that's also not realistic to do in a very short period of time. Finding the psychologists and the special staff that's needed for that is hard, and finding that in big facilities is a challenge. So I'm going to stand in opposition to the bracket because I think 1288 is something that we have to take action on to fix because it's a real problem. And, you know, when my brother put it that way, that we can't put them on an island and give no options to figure out a way to help them, it really hit home that's essentially what we're saying is we don't want to do what we need to do to make sure that a particular group of people are not left out in this mental health challenge.
1 minute.
Thank you. But he said the other thing you guys need to wake up and realize is this whole EPC system is broken. It's broken horribly all across Nebraska. He said if you were starting in the legislature next year, I'd tell you your eight-year mission is to figure out how to unscrew that mess, because he said all law enforcement is a challenge with it. And he said there's people dying because we're not able to get them where they need to be to get treatment. So that's the challenge I think we have down the road. But for now, I stand in opposition to the bracket in supporting of 1288. Thank you, Madam President.
Thank you, Senator Brewer and Senator Raybold. Senator Von Gillern, you're recognized.
Thank you, Madam President. I wondered if Senator Raybold would yield to a question.
Senator Raybold, will you yield?
Yes.
Thank you, Senator Raybold. I'm looking at the committee statement and I'm trying to get caught up here and make sure I've reconciled the amendments in the original bill. the second to the last line in the committee statement talks about section 29. It says it would amend to require state hospitals to include persons subject to tribal commitment orders as priority admissions when such hospitals lack sufficient capacity. I've looked in section 29. I'm really not seeing that verbiage there. Would you like to comment to that, please?
Yes, thank you, Senator Von Gillen. There is nothing in LB 1288 that indicates tribal members have priority over any other Nebraskan waiting to be admitted for treatment to any mental health, medical facility at all. There is nothing in this bill that says that. They do not have priority over any other Nebraskan because we know that many facilities don't have any available beds for anyone.
So the committee statement regarding section 29 is not accurate?
That is not accurate.
Okay, thank you. I yield the remainder of my time to Senator Albright.
Senator Albright, you're yielded 3 minutes, 37 seconds.
Thank you, Madam President. Thank you, Senator Von Gillen. I am certainly not wanting to separate people as for who they are. I mean, this is in my district. My district has asked me to please not let them negotiate with them what they want to do. These people are currently obviously getting to where they need to go, even though there isn't a bed where they're taking them sometimes. But we are here talking about my district with the natives that live in our particular county, and we are always there to help. We've gotten so many different things taken care of. I mean, it's a great relationship. It's amazing what they can get done. I just have spent a lot of time on the reservations in a lot of different committees that they've asked me to come visit with them, whether it's the tribal, the village, or the natives that get together, and everybody has their own projects that they're working on. And I have gone to the, whenever they come down and tell us what their different things are that are important to them. But trust me, I have worked with them over the 8 years that I've been here, and they will find a way. But I don't believe that this is the vehicle to get to where we need to go. If they can come and do a memorandum of understanding over a fire truck, we can certainly figure out how to do the memorandum of understanding for mental health and or sex offenders. Now, I will definitely take issue with sex offenders that they just don't want them in a jail, but I'm sorry. I don't know where else that they would be taking someone, but if they are truly convicted of a sex crime, I would definitely think that they'd have to sit there for a while. I mean, I can't imagine that a judge is not going to have them, because I know in the Thurston County Jail, we do have a lot of different folks that are sometimes held there because if there's not a bed available where they'd like them to go, then they have to go somewhere. And I think they're treated very well, no different than anyone else. But I have to stand with my district on how they feel about this particular bill. And will we work with them, and will we try to find an answer? Again, I think that the facility that they have is pretty fabulous. I mean, it's been there for some time. And I would implore you to think about what our needs are in my county as well, not only with the native tribes, but we have, the taxes that we pay in our area. I mean, we don't have the money that other counties have. We just don't. We're the poorest community for a lot of different reasons, but this has just got to be something. Even if they asked Dakota County, the sheriff up there would tell you the same thing. They don't have the people to take them, and they don't even have places to take their mental health cases, as well as I'm sure they do whatever they do with their sex offenders. But everybody needs to take a step back and understand that if you're domiciled in the native Indian country, then I would hope that if there's an amendment up here that it is changed to be to just recognize.
Time, Senator.
Thank you, sir.
Mr. Clerk, for items.
Mr. President, new A bill, Legislative Bill 1331A, introduced by Senator Merman. It's a bill for enacting new appropriations, appropriate funds aid in the care of the provincial Legislative Bill 1331, and declare an emergency. New LR 392 from Senator Hansen, that'll be referred to the Executive Board, as well as LR 393 from Senator DeBoer, that'll also be referred to the Executive Board. That's all I have this time, Mr. President.
The legislature will now stand at ease until 6:30. When we return, Senator Albright, Senator Raybold, you are next in the queue.